That's if they have to. But for now, it's muted.
All right, ladies and gentlemen, I had to reboot my computer, but I think we're going now.
Okay,
Call the dockets. I'll ask for announcements from the attorneys. Anyone who's present who either doesn't have an attorney or your attorney does not answer, please make sure I know that you're here. Apart from that, please leave your electronic device muted. Atascosa County.
can you hear us?
Yes.
Okay.
Otherwise, please keep your device muted. State versus Sandy, Iowa. All right. No show, Nicholas Vasquez.
He is present here at the probation department, Your Honor.
All right.
Council present for that, that's NTR. I'm just sending back the paperwork with my signatures.
Colby Bedwell.
Your Honor, my name's, good morning. My name is on that case. However, I believe that's a prior representation on a prior MTR. It was resolved in October.
All right. Colby
He's in
Bedwell.
custody. He's in custody, Your Honor.
I ask somebody to get with him on a court-appointed attorney affidavit. David Benavides Jr.
Your Honor, he's in custody and Mr. Flores represents him, and we've reached an agreement.
I believe it's an open plea, Judge.
That's correct.
Okay. All
That's
right.
what
Right now, I just want to know who's here, and we'll get to details.
In custody, Judge.
Ramiro Terran.
Custody judge, that's the MTR. We are not in agreement and we will be going open to the court on the MTR.
Okay. Again, just let me know that you're here, and we'll get details later.
Yes.
Shannon Leanne Rice.
Your Honor, this is my client is found incompetent in Gillespie County. She's recently been found competent, and she's currently in Gillespie County Jail on 3 credit card charges. I spoke to the DA's office this morning to confirm that information.
Okay, and I'm sorry, she was found competent or incompetent?
She was incompetent, but the state hospital on February 27 found her competent, I believe. And so now she's in Gillespie County, so she can answer to the 3 charges
Restored to
there.
competency.
Sir?
She's been restored to competency is what we're being told.
Yes.
All right, page 2. Jairo Gaitan, state versus.
We are present on that, Judge.
All right, no show, I'll recall. Cristobal Estrada.
Your Honor, this is James Anders. That person is in custody, and I would like to get a breakout room with Mr. Lamb.
Okay.
Thank you.
Julio Araujo III.
Present on that, Your Honor. He's in custody. This is a case from December. We're just waiting on the judge's ruling.
Okay. Morgan Booth.
Good morning, Your Honor. She's present with counsel, and I can be put in a breakout room whenever the court has a minute.
All right, I'm going to make Ms. Riley the host, ask her to make me the co-host. And she will be in charge of breakout rooms. Ricardo Arriola, Jr.
Judge, he's in jail. That's a motion to suppress. We're ready when you are.
Okay, how long to hear this you expect?
I think it'll be less than an hour altogether, both sides. Mr. Lamb's the prosecutor.
Yes, Your Honor. And if I get a chance to speak to Mr. Bettis in breakout room before we do that.
Okay. Gene Caffey.
Good morning, Judge Edward Adams for Gene Caffey. He's in the Atascosa County Jail. Plea paperwork was submitted last week and we're ready.
Chase State versus Chase Renee Hall. Chase Renee Hall, no show. Whitney Staggs.
John Lamberson here for Mr. Staggs, Judge. He's in custody. I've already conferred with Mr. Thornton on this. We don't have an agreement. Should take about 10 minutes for the reduction PR bond hearings.
All right. Crescencio Medrano.
Your Honor, I represent Mr. Medrano. I sent him a waiver of arraignment, but I haven't received anything back from him and I haven't had contact with him.
No show for the time being.
He's in custody, Judge.
Oh, well, okay.
And I'd ask for a short reset so that I can go visit with him in the jail to get him to sign a waiver.
All right. Chesley Wisdom.
I'm present on her, Your Honor. This is David Wilkerson. If I may have a breakout room as appropriate with Mr. Lamb.
Okay, is Ms. Wisdom present?
She should be. If she's not, I shall call her and report back to the bench.
All right, I'll mark her no show for the time being.
Thank you, Your
Rick
Honor.
Cortez. Says bench warrant from Bear County. Do we know if he's in custody?
Yes, Your Honor, he's in custody.
Okay, is in Bear County or locally?
Locally, the jail census from today says that he's in our custody.
Okay, we'll check on Mr. Cabañas. All right, now my computer's locked up. Well, so far taking it to have it worked on Friday doesn't seem to be helping. We'll see if it unlocks, if I have to reboot again. Okay, as I recollect, the add-on docket was short. Let me find it on the web. All right, State versus Victor Hernandez.
He's in custody, Judge.
Okay. Good, and here it comes. Okay, so has he filled out a court-appointed attorney affidavit? If not, please have that happen. Francis Cantu.
He's also in custody.
All right, same request. Atascosa Civil, Turnkey Processing Solutions versus Texas Material Group. Has that been reset or anything?
No, sir, I haven't heard from anybody, so
Okay.
I'll check my emails.
It saved me 4 hours. In the interest of Haley Marie Ramirez, a child.
Good morning, Your Honor. I'm present on that, Judge. The respondent is present, and it's my understanding he is pro se. We're set for the termination portion of a termination step parent adoption. I don't think it will take any more than 2 hours.
Okay. That's Mario Ramirez.
Yes, Your Honor. He's muted, but he's here.
All right. Mr. Ramirez, I'm asking you to unmute your device. Okay,
Yes, sir.
all right. And are you ready to proceed on this case?
Sir, I don't have a lawyer. I don't know if y'all could appoint me one or I had to get one myself.
Right, sir, you're going to have to hire your own attorney in this case. So I'm asking, are you ready to proceed today?
Judge, this
Not-
is a
not today,
termination,
not-
Judge.
I'm not ready.
Okay, I'm sorry, Ms. Harkins.
Judge, this is the termination proceeding.
Right. All right, so Mr. Ramirez, are you ready to proceed?
I'm not ready, but I got most of the papers ready, but I don't want to terminate my rights.
Okay. All right, and does either side think it would do any good for Ms. Harkins and Mr. Ramirez to confer in a breakout room?
Judge, I'm fine to attempt that, given that I know we won't be up for a while. I'm fine to talk to him.
Okay, well, I will ask you to do that.
Yes, Your Honor.
All right, anyone else told to be here today? Your case was not called. Sorry?
Jolyn Martinez, I had court today, but my case wasn't, you didn't call my name.
Okay, what sort of case do you have?
I think it's 3 felony charges.
And in what county?
Atascosa.
All right, what says the DA's office?
Look at that.
Your Honor, it's for a count of possession under gram and prohibitive substance. By our record, she's set for arraignment on March the 3rd.
Okay, well, Ms. Martinez, do you have an attorney to represent you in this matter?
No, sir, I spoke to Jeremy Fernandez and he was gonna give me an appointed attorney. But
Okay.
I think I'm gonna get a lawyer, right? A lawyer.
All right, ma'am. Well, you're actually supposed to be here on Wednesday, not today.
Okay, because I got my paper sent to me and it said that it was March the 1st.
Okay. All right. Well, I'm going to ask you to remain on hold, and we'll ask you to speak with Texas Rural Legal Aid, the Public Defender's Office, in a moment, shortly, and we'll see if they've got your paperwork finished where they're requesting, you're requesting an attorney. And I see that Chesley Wisdom is one of the people that we have in the queue.
Yes, Your Honor, that was my case, David Wilkerson. It is on page 3, the 1, 2, 3, fourth one down.
Okay.
And I just need to speak to Mr. Lamb when we have an opportunity for a breakout room.
Okay, it looks like she is appearing. Chesley's iPhone just signed in.
Great, thank you, Your Honor.
All right, and I'm going to, I have a whole bunch of people here in the pending determination queue. I'm going to look at them and see if there's any of them that are for court today. And Mr. Wilkerson, were you appointed or retained in this case?
I was appointed, Your Honor. I was originally, it was before Judge Ellison, but he had to recuse himself because of a conflict, I believe, with my client's family.
Okay. All right, and I'm going to ask Texas Rural Legal Aid to get with Ms. Wisdom. There is her case has been opened up, but there is the financial information has either not been entered at all or it's not been completed. So if you will go to her where she's already in the system and get her financial information in there, I will approve that, and assuming she is qualified, and then appoint Mr. Wilkerson to represent her.
Just to let you know, Your Honor, this is my 3rd appearance on this case.
I understand we got a lot of stuff resolved last week. We've got people in the system multiple times, and we've got people in the system who were sort of in limbo. And I disposed of a bunch of them, all of them that I could last week, got them moved up. But she's one of the ones that the financial information's not in there. So,
That's fine, Your Honor. I just wanted to give you a heads up. Thank you very much.
okay, we're going to take a brief reset, and I'm going to look at the people in the queue. And then we'll come back and we'll start with Whitney Staggs, and I'll let everybody who needs to confer with the DA's office to get with Ms. Riley and work on that.
Thank you, Your Honor.
I had to put your spotlight you. I was asking myself, is that a Spanish flag on the wall behind you or in the cabinet behind you? And I saw it was.
Yes, Your Honor. I'm in my legal assistant's office right now.
Oh, that's fine. That's fine. I just, it
But
looked
you
like
are-
a Spanish flag, and I was peering. I had to spotlight you, and you moved your head, and I could saw
Well,
the pillars from the
you're right
pieces
on
of it.
you're right on the money, Your Honor.
All right, I'll be right back.
Okay, thank you.
Kenny Lamb, you have several people that want to see you. So can I put them all in the breakout room with you, or do you prefer one by one?
I'll prefer one by one, and then I'll have them, when one of them leaves, just have them ask for the next person to jump in with me.
Okay, so I'm going to put you with James Anders first, okay?
Perfect, thank you.
Breakout room 1. And Mr. Arguez with Morgan Booth, I'm going to put you all in breakout room 2.
I'll let him know he's in another court right now,
Oh, okay.
but put him in there. He'll be there.
Okay. So Morgan Booth, you're going to get an invite to breakout room 2. So just please accept that, and your attorney will be there shortly. Megan Harkins and Mr. Ramirez, y'all need a breakout room as well?
Yes, thank you.
We'll put y'all in breakout room 3.
Thank you.
Mr. Ramirez, you'll get an invite to that room, so please accept that to go into the room.
Yes, ma'am. Yes, ma'am.
Yes, sir. Anybody else need a room?
I need a breakout room with Kenny Lamb, please.
Okay, you're on the list, okay? He's in
Thank
a
you, ma'am.
room right now. Uh-huh.
And Lori, this is David Wilkerson.
Yes.
Chesley Wisdom, they're getting some of her financial information to make sure she qualifies for a appointed attorney. Somehow that was missed. I've been appointed to her, and then Judge Ellison had to recuse himself because of some familial connections
Yes,
with
sir.
my client's family. So I think he's meeting with the whomever is appropriate to give them the financial information. And then if it all goes smoothly, I just need a short visit with Mr. Lamb in a breakout room.
Okay,
It should be real quick.
okay. And is your client talking to the public defender's office right now?
I believe she is. That's what the judge instructed her to do.
I don't know if they're on here. So anybody from the public defender's office that needs to speak to Chesley?
Ms. Riley, this is Dan Rivas. I'm here. I'm waiting for instructions.
Do you want me to go ahead and put y'all in a breakout room? You and,
Yes, please do. I'll go ahead and take care of that.
okay, and I think there's 2 or 3 other people that needed to be interviewed. Did you get those names?
Thank you, ma'am.
Yes, sir.
I did.
There's Victor Hernandez on the add-on page, and then Francis Joseph Cantu. They're both in jail. They both need to be interviewed. I don't know if you have a copy of the docket in front of you. That's the add-on.
Yeah, I got Victor Hernandez and Francis Cantu. I have it here.
And then on page 1, the third one down, Colby Bedwell. I believe he needs to be interviewed. He's also in jail.
Okay.
And then, let me see, I think there was
Yeah, if you call them by.
On page 3, Chase Renee Hall. I don't know if that person's in jail, I think. I'm not sure where that person's at, so he may not be present.
Again, Ms. Wisdom is already in the system in TechShare. There's just no financial information in there.
But yeah, y'all should be able to log in and everything should be fine.
Okay.
Okay, very good. Thanks, bye-bye.
I'm going to put Mr. Rivas and Chesley Wisdom in breakout room 4. Let me see if I can find the names.
Thank you.
So Chesley, you're going to get an invite to breakout room 4 if you'll please accept that.
Okay.
And the attorneys, I did post the resets under the chat. So if you want to look at that, if you need those dates. And then just let me know if you need a breakout room, please.
Gloria, I don't know if you saw, but I'm done with my breakout room with Kenny Lamb, breakout room 1.
Okay.
Thank you.
Let me see who's. So Kenny, I'm going to put Adrian Bettas, you're next online. So I'm going to put you in breakout room 1 if you'll accept that, please.
Thank you.
All right, is Jolene Martinez still here?
Yes.
Yes. Jolene? And Mr. Adams, is he conferring or?
I'm right here, Judge. I'm just waiting.
Okay, if you check your email, Ms. Martinez was one of the ones who was in the system and she's eligible for an attorney. The system selected you as the next one on the list. I went ahead and appointed you. She is not supposed to be arraigned until Wednesday, and she told me that she thought she wanted to hire her own attorney. If a new attorney who's retained appears, that's great. Until then, you are her attorney.
Okay, and her arraignment is going to be Wednesday, you said?
Yes, that's well, first appearance anyway. I said that, but.
Okay.
I'm going to put her on the add-ons.
Thank you. Judge, once I speak with her, may she be excused for the day?
Certainly.
I'll go ahead and put you in a breakout room, Mr. Adams.
Please do. Thank you.
And Jolene Martinez, if you'll accept the breakout room, I'll put you all in breakout room. I believe it's going to be 5.
Judge, I posted my reset date. May I be excused?
Yes.
Thank you.
Your Honor, can I make an announcement on Sandy Ayala?
Yes.
Judge, we were set for a plea this morning. I have the paperwork from Mr. Lamb. However, I was unable to visit Ms. Ayala to get that signed. So if we could have a 1 week or 2 week reset so we could, so I could get that plea paperwork signed and submitted to the court.
Okay, that's fine, and I'll announce for all the attorneys on the criminal cases. I desperately want us to be able to get back to having jury trials and moving this stuff along, but until that happens, as long as the attorneys on the state and the defense are happy with whatever the reset date is, that's fine. I'll approve it. If y'all have a dispute that I need to resolve, I'll resolve it. Apart from that, just check with each other. If you're both good, just file it and that'll do it.
Thank you, Judge.
And Your Honor, if I may, on page 2 is Jaido Salomon Gaitan, and it's an MTR, and that defendant is in jail.
Okay.
Court's information.
Thank you.
Your Honor, may I make an announcement on Ms. Booth's case?
Yes.
Okay. She's waiting for her COVID test results so she can walk on over to the probation office and do her PTD paperwork. She should be getting that today or tomorrow.
Okay. And who is that on?
Morgan Elaine Booth.
All right. So let's just get her a date, I guess.
Yes, Your Honor. I'm gonna put the date's already posted on the chat. I'll just post a new court date on here.
Thank you.
Thank you, Judge.
Laurie, Kenny's ready for whoever's next to talk to him.
Thank you. David Wilkerson, I'm gonna put you in breakout room 1 with Kenny Lamb.
Thank you, Lori. This is David Wilkerson. Appreciate it. Could you tell me what number again?
Number 1.
Okay, thank you, ma'am. Appreciate it very much.
You're welcome.
All right, in Jairo Gatan from page 2,
Yes, Your Honor.
is it, he also is in the he also has been entered into the system, but does not have any information on him. By that, I mean he's in texture.
Right. He's in custody, it's MTR.
But I just need to make sure that whoever's doing this for TRLA doesn't put him in there again.
I believe he's already been interviewed.
He may have been interviewed, but his financial information was not put into texture and saved effectively. It may have been put in, you may have hit save, but it didn't get saved.
Okay.
So that's why I have him in the attorney requested file or queue.
Honor.
Yes.
This is Roseanne Perez. I was supposed to appear in court this morning, but I was having a hard time logging on to the Zoom. So I'm online now for court.
All right. What sort of case is this? The adoption?
This is a criminal.
Okay. And what county do you have court in?
Atascosa County.
All right.
It's my first time.
She's one that's on the docket for Wednesday.
Okay. Apparently we had some cross communication. All right, ma'am, do you have an attorney to represent you in this matter?
No, sir.
Are you able to hire your own attorney?
No, sir.
Okay. What is
Well, I'm working on trying to get one, but I'm still trying, I would have to just get a court appointed for now.
Okay. What is Ms. Perez's cause number? Okay, somebody said she was on the docket for Monday or for Wednesday.
It was for Wednesday, Judge. It's 21-261 and 21-262.
All right, ma'am, I'm going to ask you to stay on the line and we will get the public defender's office to speak with you and take your financial information, see if you're eligible for a court-appointed attorney.
Okay, sir. Thank you.
And Chesley Wisdom is actually in the text share twice, so we need to get that missed.
Lori,
Yes, sir.
I apologize. I did mean to interrupt you. This is David Wilkerson. I just got through speaking with Kenny. He said it looks like you've already posted a reset for 5/4/21 on Chesley Wisdom.
No, I didn't post that. I mean, I put the reset dates out on the chat.
Oh, okay. So you're going to have to give me a heads up. I thought that that's what we did. What I'm needing to do is get a waiver of arraignment and have Miss Wisdom sign it, and then we'll e-file that, and then we have dates of 3/8. I believe you said Kenny said 3/8/21 and 5/4/21. But I don't know that we need the 3/8/21. In fact, I know we don't.
Have y'all already filed the waiver of arraignment?
No, ma'am. I've got to get her to sign it. Do they send that with the discovery, or how do I obtain the waiver of arraignment?
I'm sure Jennifer already emailed that to you. I'm not sure what date, but
Okay.
she probably emailed that to you
Okay, I'll check that. I've been away for this weekend. I know Kenny just sent me the discovery 5 minutes ago. Oh, and pardon me, he asked me to go ahead and send the next person into the breakout room, please, ma'am.
Okay. So that's Mr. Cabanas.
Pardon me?
Mr. Cabanas is next.
Oh,
Are
okay,
you-
great. Yes, ma'am.
Yes, ma'am.
Okay, I'm gonna put you in breakout room 1 if you'll accept that, please.
I sure will.
And Lori, not to monopolize your time, or am I good to go, or do I need to report back to the judge?
I think you have to post your reset on the chat like he wants you to do.
Oh, okay. I'm sorry. I was under the impression Kenny said that you had posted it.
I don't post those, sir. I only post the dates, and it's up to y'all to.
Okay. Very
let-
good.
Of course, but I don't know.
This is
I
the
don't know if
first one I've done, so you'll have to forgive me.
Yes, but sometimes they'll reset them to monitor the waiver of arraignment for the return of that. So if you haven't done that, I mean, you might want to.
Do the
reset.
3/8/21 and get that waiver of arraignment in.
Yes, sir.
Okay, that'd be great. Thank you very much
So
for
if
your
you'll
help.
post that in the chat, please.
Yes, ma'am. Thank you.
Thank you. Jolynn Martinez, are you still on the Zoom hearing?
No, I told her it was okay. The judge said once I talked to her, it was okay to leave.
Okay, thank you.
But
I
I
wasn't
have her
sure.
contact info and I'll be in touch with her after docket today.
Okay, I just want to see if she needed to be interviewed by the, but you got assigned already, right?
Yes, ma'am.
Okay, good. Okay, sorry about that. I missed that. Okay. Roseanne Pettis, I'm going to put you in breakout room 4 with the public defender's office so you can be interviewed, okay? If you'll accept that, please.
Yes.
Okay, and the public defender's office, I said that Chesley Wisdom was in the system twice. She's still in the attorney requested part of the text share queue, and that's the one that actually has the cause number in it. So I don't know how you want to handle that, but I think that you need to put the financial information in there, and then we'll deactivate the case that doesn't have the cause number in it, which is the one I just approved.
We'll check on that, Judge.
Okay, Staggs, do we have any pleadings I need to look at on the bond?
Judge, Mr. Thornton sent around a proposed exhibit 1 to which we have no objection. There's nothing we're offering to the court other than what's in our motion. That's part of the court's record.
Okay, when did Mr. Thornton send that?
About 10 minutes ago.
Whitney Staggs.
Judge, that's just a copy of the 404 notice that we provided in this case, just offering it as an exhibit for the court's purposes and setting bond.
And again, we have no objection.
All right, is that a Mr. or Ms.?
It's a Mr. Judge. He's in Atascosa County Jail.
All right. We could get him to the jail.
Yes, sir. Does anybody else need a breakout room with Kenny Lamb?
All right, this is Mike Finkel. I would like a minute to discuss with whichever prosecutor is handling Crescencio Medrano. I'm not sure if that's Mr. Lamb or somebody else.
I don't know. I'm not sure who the ADA would be on that.
Pretty sure that's mine. I'll be more than happy to meet with them when this hearing's over.
Okay.
It's an unauthorized use case.
Judge Wilson?
Yes.
I believe my case can be handled pretty quickly. We've got Bradley here, and I believe he sent you a judgment. We've got Julio Arteguejo has been waiting on that case.
Okay, and all right, and I'll get. Right, let's get the bond hearing done.
Your Honor, we checked and
Yes.
notices went out February 22nd.
Is that an announcement for me or an announcement for Judge Ellison?
Sorry, Judge, that was I had the other court on the line.
Okay. All right, if you'll let me know when Mr. Staggs gets to the jail.
sure. Yeah. Yeah. Okay, let me take it off video.
Because I think may have Mr. Staggs available at the jail.
All right, give me just a moment. Okay, are you Whitney Jean Staggs?
Yes, sir.
Okay. All right, and who's going to be doing this? TLA is Mr. Boyer, Ms. Jameson?
Judge, it's me, Mr. Lamerson. I'm going to be representing Mr. Staggs. It's our motion.
All right, go ahead, sir.
Yes, Judge. Mr. Staggs is currently being held in the Atascosa County Jail on a state jail felony UMV, enhanced from a state jail to a third based upon 2 previous state jail convictions. He has a bond set in the amount of $20,000. After lengthy discussions with Mr. Staggs and with his mother, there's no ability for him to make that bond. We're asking the court at this time to grant him a PR bond due to the nonviolent nature of the offense, the lack of disqualifying events as it relates to the governor's order, and just because we're not going to be able to get a jury trial for a very long time in this matter, and there's no chance he's going to be able to make bond to get out. We're willing to abide by whatever conditions the court sets as it relates to bond. As Mr. Thornton provided to the court, there is previously a bail jumping charge against Mr. Staggs back from 2006, which is about 15 years ago. Mr. Staggs has run into the law problems since 2006. He's never failed to appear, to my understanding. At this time, we're asking the court to reduce his bond, or in the alternative, grant him a PR bond so that we can prepare for trial in a manner, and so that he doesn't sit in jail for the next 1.5 years, 2 years on a state jail felony. Thank you.
All right, Mr. Thornton.
Judge, the facts of the case are basically worked for a company where he used their truck. He signed a thing he wouldn't use it for personal matters and then drove it to Dallas without permission and basically abandoned the vehicle in Dallas. The state's exhibit number 1, which I'd like to formally offer now with Mr. Staggs available. There's no objection from defense.
Correct, no objection.
All right, without objection, state's exhibit number 1 is admitted.
Thank you, Your Honor. Shows that he has a substantial criminal history that has carried on now for a number of years, starting with a bail jumping case out of Tom Green County. You can also see almost actually every single conviction is from another area of the state or from another county, showing that he does frequently travel, making him a potential flight risk. Your Honor, we would ask that the bond in this case remain in place. We think it's appropriate, especially given his history of bail jumping.
Okay, and what is Mr. Staggs' plan if he's released?
Judge, assuming that the terms and conditions of his any pretrial order allow it, he's going to reside with his mother up in Dallas until the time of trial or until the court requires him to come here for hearing. I've conferred with his mother at length. She's willing to accept him there. He has no living situation there in Atascosa County. He is very aware, we have talked at length, he is very aware of the severity of the circumstances should he not appear as the court requires for each and every hearing going forward. He's not going to FTA on any on this charge.
And how long is Mr. Staggs alleged to have kept this vehicle on his personal excursion?
About 8 hours, Judge.
Mr. Thornton, is the state in agreement with that?
Your Honor, I was actually looking into that. I figured you would have that question. The I believe that could possibly be true. I don't have the report yet from Dallas. We've requested it, and so I can't say for sure because the reports are very vague about timeframes. Report that I have, but I believe that is true.
All right. So the state is enforcing employer rules with indictments?
No, Your Honor. He was told to return the item and he failed to return it. The agreement that he signed said that he wouldn't use it for personal matters. So at that point, it becomes theft.
Judge, certainly at trial, our contention is going to be that there was no intent to deprive the company of the matter, but that's going to be a fact issue for trial, we assume.
But more importantly, it's unauthorized use, which is how it's charged because he violated his company policy. So at that point, it becomes unauthorized. And he has a criminal history to kind of show intent. If it was just like a no criminal history, one-time thing, I think we may infer his intent differently than we would in this case.
Okay, well, I'm not going to get into commenting on the merits of the case. I'll order a $20,000 PR bond with the standard terms and conditions for a felony case here in Atascosa County. Somebody will get that to me, I'll sign it.
Thank you, Judge. I'll get it to you today. I'm going to get a breakout room with Mr. Staggs, but after that, I may be excused to go to Frio County.
Sure.
Thank you, Judge.
I'll put y'all in breakout room 6. Atascosa County Jail, if y'all can accept breakout room 6. Mr. Staggs, you might need to accept that possibly.
Okay. It hasn't popped up yet.
Okay. Is there going to be a reset date on that one?
It just whatever date it would normally go to, unless it already has dates. I don't know if it was set new or early for this to be heard. And is TRLA meeting with Charles Bedwell, Victor Hernandez, and Francis Cantu?
He's with Roseanne Pettis right now. I don't think he's been to the jail yet to speak to anybody there. I don't believe. I'm not 100% sure though.
Your Honor,
Yes,
do you have a moment for a brief announcement?
yes.
Sorry, I accidentally muted this computer. I've spoken to Mr. Bettis about our motion to suppress on Ricardo Arreola. My officer is going to be available around 10:30, but we've conferred. Is there any way that we can do the hearing around 11, Your Honor?
I have no objections, Judge.
Certainly. I was about to call that next, so 11 o'clock is good.
Thank you, Judge.
Thank you. May I be excused until then, Judge?
Certainly.
Thank you.
Okay, and who's here? Who's doing the interviews for TRLA?
It's Dan Rivas, Judge.
Okay, is he still in a breakout room or?
I believe he might be out. Let me look real quick. He's still in there, but
Why don't you put me in there, please?
yes, sir. Number 4, Judge.
Lori, this is David Wilkerson again. I'm sorry to bother you. I was in the chat room and now I can't seem to get back into it. Do you have any suggestions?
What room?
Just the chat room, just the chat box, so I can post the reset.
I don't know. I mean, you should be able to just click on the chat and be able to type and do it to everyone.
Yes, ma'am. I understand it, and I've done that. And I was there a while ago. I saw everybody. I hit chat, and I'm just not having any luck bringing it back up. And all my staff is gone right now. If
Mr. Wilkerson,
I don't know what.
Mr. Wilkerson, what date were you requesting for?
I guess what Lori told me is that I thought what you told me is that you wanted me to do the 3/8/21 so that I could get the waiver of arraignment into you.
Yes, that would be.
And then we would reset it for 5/4/21.
Yes, that the waiver of arraignment you should have the 5/4 date, and then we'll have it reset to 3/8 to monitor that we get the waiver in.
Okay, but what I'm having trouble with, Kenny, is I can't get into the darn chat room right now.
You mean the chat to type out to everybody the
Yeah,
date?
yes, sir.
Mr. Wilkerson, to help you out, I'm going to type it in for you.
Okay, thank you, Kenny. I was there a while ago, but I lost it, and all my staff's gone, and I'm a little verklempt right now.
Okay. That should have been sent to everybody.
I see it right now. Do I go back in and tell the judge I post that and ask to be excused?
Ms. Riley?
I don't believe so. As long as it's posted there, you should be good. Did you find your waiver of arraignment that was emailed to you?
No, ma'am, I've not had the opportunity to look at that because I've been doing this.
Okay.
But I'm sure it's there.
If not, call us later on this afternoon, okay?
Okay, thank you so much for all your help.
Yes, sir.
Thank you, ma'am. Thank you, Kenny.
Judge, I'm gonna show you.
I'm gonna leave. Get out of this thing. I'm sorry, dear. But a while ago, you go ahead and come on. But a while ago, the chat.
Excuse me.
Ma'am. Hello.
So today, sometimes for report, I need to do them for this week. So we can set them for that week and I can.
Ma'am. Ma'am,
Okay.
Yes, Ms. Bettis.
We'll get it straightened out. You just tell me what you want, okay?
You're muting yourself when you're talking.
you hear me now?
Yes, ma'am.
Okay, I did the paperwork for
It's
the
funny, when
court
you said
appointed.
that, I started looking to make sure. So this guy
Oh,
showed
do I have
Okay.
to stay still in court or I go?
up, he showed up today.
Hold on, ma'am, until it shows up on my system and I'll get an attorney appointed. And then we'll let you know who it is.
Okay, thank you, sir.
And then
And I'm ready for the jail to bring in Mr. Arwijo whenever Mr. Lambert and Mr. Thornton are ready.
Ready, Your Honor.
And I cannot see what's going on, so let me know whenever he's there at the jail. All right, do we have a state's attorney?
I'm here, Your Honor.
All right, State versus Philip Arwillo. Are both sides ready?
Julio Araujo. Philip Lambert is ready for the defense, Your Honor.
I'm sorry. I conflated the attorney and his client. Okay. All right, Mr. Arwillo, I've thought about this case very carefully for quite a while. I think I've found there's enough evidence to say you're guilty, or actually I previously had found you guilty of the third-degree felony. And at this time, I will sentence you to 40 months in the Texas Department of Criminal Justice with credit for time served, which I believe amounts to about 287 days. That's 21 since February the 8th. Is that correct?
I think so, Your Honor.
I think that's right, Your Honor.
All right. And this was an open plea so that Mr. Araujo retains the right to appeal? Was there a cap? I don't recall.
I believe the cap was 5 years, Mr. Thornton, but I can't recall.
That's correct. It's 5 years.
Cap. All right, so you understand, sir, that because I have followed the plea bargain agreement that you had with the state, and the sentence I have imposed does not exceed what you have agreed to, you will not be able to appeal this matter?
Yes, sir.
All right, then I will certify to the Court of Appeals that you have waived your right to appeal as part of a plea bargain. And I will sentence you to 40 months confinement in the Department of Criminal Justice. Is there any legal reason why sentence should not now be imposed?
None that I know, Your Honor.
All right.
No,
The
Your Honor.
order, judgment, decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent in the Department of Criminal Justice. Court will, your sentence will commence today. You'll receive credit for all the time you have spent so far in jail on this charge. And is that 287 or is that a different number?
287 is what I had, but I thought.
I had 6 months the last time that I was here, and then I got 6 months. I'm like, maybe, I think on the 8th would be 6 months shy this time.
Your Honor, I can double check, and if there's a difference to that 287, we can do I can ask Mr. Thornton to file something.
All right, so what I'll do is that I will agree that if the state and the defendant are unable to come to an agreement as to the number of days that Mr. Araujo is entitled to, that if Mr. Lambert will file a motion for new trial in a timely manner, I'll grant the new trial just as to punishment and just as to the question of how many days he's entitled to credit for. I'll go ahead and sign the judgment I have. Okay, all right. So apart from that, the sentence will commence today. You'll be confined for a period of 40 months. You'll receive credit for all the time you have spent so far in jail on this charge. That is 287 days or perhaps more. We'll determine that. And it will run concurrently with any other charge you may be under. And I will sign that right now.
Thank you, Your Honor.
And all right, give me just a moment.
Lori, after the judge is done with this, can I get a breakout room with Mr. Arguello to talk about the case real quick? Thank you.
Yes, you may.
Ms. Riley, I just sent you a message. Could I get a breakout room with LG 17130?
Kenny, do you want to just go to breakout room 1 and I'll put them in there with you?
Yes, thank you.
Okay, I'm not actually finding when I look here.
The judgment, Your Honor?
No, I have the judgment. I'm not finding the waivers for me to put the post-trial waivers. I need to approve that on the motion on the right to appeal, things like that. That has to be signed afterwards.
I don't think we've filed one because we were doing the open plea, but we can get one done right now while I'm in the breakout room, Your Honor. Waiver of appeal?
Well, no, I mean, it was a 5-year cap or it was open.
I can't recall.
There should have been a set of waivers in any event, just when we started this, when he pled true and all that.
Judge, I think this was the hearing where he initially said that he was going to plead not true to everything, and then when you asked him, he ended up pleading true.
Okay.
And so when I think we refer to a cap, there was a cap of 5 years based off of the previous sentence, but I don't think there was a plea agreement of a cap of 5 years.
No. Yeah.
Oh, okay. Okay. All right then.
That is correct. That's
all right, because the judgment I was sent is judgment adjudicating guilt.
Well,
it was a deferred.
Then maybe I'm wrong on that part of it, but
wait.
Hold on. Let me.
One of those is incorrect, so we should.
Yeah, maybe half of it. Let me. No, it was definitely a deferred. So then I don't believe there was a cap, Your Honor.
Okay, then I just need the right of appeal that says he can appeal.
Okay, we'll get that.
And Bradley, if you send that to me, I can get that signed right now.
I will work on it.
Ms. Riley? There should be
Yes.
a video camera for Trooper Gonzalez. Could you also put him in the chat room with me?
Sure.
Thank you.
Sure can.
Bradley Glenn.
Okay, do we have any idea who Austin Renner is? Possession of controlled substance?
Is that on the docket, Judge, or where are you?
No, I just. His financial information has just apparently been entered into the tech share system.
That's what.
And I don't know by Dan from
36 and
TRLA, but he's not on the docket for today. I'll be back.
Say, Mr. Thornton, on this case, it's non-ag, right? Can you hear me? Or what?
Julio, I'm gonna get a breakout room and we can chat here in a second.
Yeah, all right.
But no, as far as it's not ag.
Are you ready for the breakout room or not?
Mr. Thornton's going to be getting me a waiver. I'm going to try to send it to the jail to get it e-signed. So
Okay. Let me know when when you want me to put y'all in that room.
I sent that a little bit a while ago, Mr. Lambert.
you can send me in there.
Mr. Lambert, you said you're ready for the room?
I am ready. Yes.
Okay. I'm gonna put y'all in breakout room 7.
Thank you.
Is Adrian Perez still on? Or is he interviewing, talking to somebody on the motion to suppress?
I believe he's gone. Let me look real quick, Judge. Yep.
I don't see him.
I don't see him, Judge.
All right, well, by coincidence, the computer appointed him to or selected him to represent Rose Ann Perez. I wouldn't usually have somebody with the same last name. But I'll leave that and we can change it if we need to.
There he is. There he is. Hello, Judge.
Yes, sir. Give me just a second.
My name is Mario. Yes.
Okay, well, I'll be with you in just a minute.
Yes, sir. Thank you. Let me try to plug it back up.
Okay, where do we stand on the adoption case?
Yes, Your Honor. We have conferred, Judge, and we did agree for the court to appoint an attorney ad litem for the child. And we agreed to reset the matter to April 7th. Judge, just confirming if that is your date because the other judges are conflicted out.
Okay, let's find out.
No, it's assigned with Judge Ellison.
Okay. I was looking at the online calendar, but I know that that's not accurate. Judge, can you tell me a date that you have right around that?
I can give you the dates.
Okay.
I just show up and do whatever on the documents.
Judge, I'll talk to Lori and then I can get in touch with Mr. Ramirez while we're still here on the Zoom. Judge, as far as the attorney ad litem, there's not many locally that do it. So I suggested Teresa Nettles or Grace Bedetta. Mr. Ramirez did not have an objection to that. So unless the court has someone they want to pull from a list, we just can't get anyone too expensive.
Okay, and that's fine. I'll be glad to go with either one of those. Probably Miss Nuttles, because I typically, as long as I can afford her, the clients can, I typically have, I probably give Miss Barrera more appointments because I know her so well because she used to work for me. They're both excellent.
Okay, Judge, we'll go with Miss Nettles. I have no problem with that. We discussed each side giving the ad litem $500 to start within the next 10 days and then getting a further amount from Miss Nettles after that. So if I may work on an order and then I can upload it in the chat as soon as I get it done.
It sounds good.
Okay.
All right, Mr. Ramirez, that's what you've agreed to do? But sir, you're muted. I can't tell if you're trying to speak because of the darkness of your box.
Okay. Yes, sir, it is.
All right. Okay, so just hold on. Ms. Harkins will work up that order. We'll give you a chance to look at it and get it signed.
Yes, thank you, Your Honor.
Yes, sir.
Ms. Harkins, do you want me to give you the dates that Judge Wilson's available?
Yes, I'm sending you a message now. We can just do it in the chat if you want.
That's fine.
Okay, thank you.
Okay, and we're still doing the Motion to suppress at 11. All right, I'm going to keep working on mine. I'm going to be gone for a minute and then I'll be back. I'm going to keep working on my not text share, but e-file queue.
Judge Wilson, I have Mr. Caffey at the jail and we're ready.
You, Mr. Adam. I muted you instead of unmuting myself. Okay, is that on a plea?
Yes, Your Honor.
Okay, I'll be back in about 5 minutes and we'll take that up then.
Thank you.
And the jail is in a breakout room right now with Philip Lambert with Mr. Aguijo.
We'll have to wait for that. All right, I just posted the WeHo judgment and certificate of appeal. So we have the Caffey plea. We're just waiting on the jail to be ready with him.
And Your Honor, if I may
Yes, sir.
if I may
Yes.
interject, just on David Benavides on the first page, we are ready on an open plea when the jail gets done and the court gets done with the next plea.
Okay.
And it's my understanding you should have that paperwork as well.
I've got some paperwork. Let's find out. Let's see. Yes. Okay, and I'm working on stuff, so someone will let me know when the jail's available. Or we have something else ready to go.
Yes, sir.
All right, is that David Benavides Jr.?
No.
Your Honor, I believe that's still Mr. Argijo, right?
Yes.
Oh, okay, yes.
It is, Your Honor, and we've signed that that waiver of, we've signed the right of appeal. That should have been emailed to you. If you'd like, I can upload it here as well.
Yeah, it was posted and it got to me somehow, and I signed that in the judgment and sent it to Ms. Benavides at the clerk's office.
Okay.
Yes, sir, I got it.
Mr. Argrijo, that's it. I'll be calling your brother and let you know. Thank you, sir. Talk to you soon.
All right. Hey, is there any way that I can, do you know how
Get
long?
a copy of the judge. If I get a copy of it, I can send it to your brother. I'll request it from the court. Usually takes about a week to get it.
Well, no, I need it. I would like to get the copy of my judgment. That way I can have it here for whenever I take off to TDC.
I'll double check with the clerks and see if they'll send you a copy afterwards.
All right. Thank you very much. I appreciate you.
Thank you.
Yes, sir.
Thank you, Your Honor.
Oh, Ms. Harkins, did you post something or?
Judge, I'm doing it right now, and they emailed me
Okay.
that they're in agreement, Mr. Ramirez. So I'm going to post
Okay,
it right
that's fine. I saw you were unmuted or back.
now.
Right?
Yes, thank you, Judge.
Okay. All right, did Mr. Lambert take off? I guess so.
Your Honor,
Yes, ma'am.
I'm still waiting for a court date. For a court appointed. I already talked to them, but I don't know
No,
what.
you've been given a court-appointed attorney. That's
Yes,
Mr.
sir.
Perez, Adrian Perez. He will be back about 11, and I want y'all to be able to speak to each other so that he can get your contact information.
Okay, sir.
You can get
Thank you.
his.
Okay, thank you.
Is the jail getting Mr. Benavides?
We're getting somebody.
Judge, I'm sorry. Chris just let me know that I had the cause number wrong. I'm sorry. I'll fix that real quick. I apologize.
Okay, what's the cause number?
It's 2011-0950.
Okay, it's fixed. And that was 415, right? That we set the Ramirez case for?
Yes, Your Honor.
Yeah, but I was like taking my. Okay, that's why I didn't say. You got your hearing. Okay.
Okay, and who do we have at the jail?
David Benavides.
All right, calling State versus David Benavides Jr. Are both sides ready?
State's ready, Your Honor.
Ruben Flores for Mr. Benavides, and we're ready.
All right, are you David Benavides Jr.?
Yes, sir.
And are you the same David Benavides Jr. who on or about May the 22nd, 2019 was convicted of the offense of violation of the duty of a sex offender to register for life and or annually?
Yes, sir.
And on that day, you were sentenced to 10 years confinement, probated for a period of 10 years?
Yes, sir.
Okay. And Mr. Benavides, can you speak, read, and write the English language?
I can't read and write.
Okay. Can you speak, read, and can you read and write any language?
No.
All right. Now, the state has alleged that you have violated the terms of your probation. Specifically, they've alleged that you have violated rule number 17 of your probation and that you failed to complete community service restitution hours at the rate of 16 hours a month, and that you failed to complete those hours in the months of June through December of 2019 and January through June of 2020. So do you understand what it is that the state's alleging you did wrong?
Yes, sir.
You understand, sir, that because you've been sentenced to 10 years confinement, in the event I was to find that you had violated the terms of your probation could be revoked and you could be sentenced to not less than 2 and not more than 10 years confinement, and to being required to pay any unpaid portion of the fine that was previously imposed on you. Do you understand that?
Yes, sir.
Okay. All right, I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke. And I'm going to ask you, are you able to see this signature on page 3?
Yes, sir.
And do you swear or affirm that everything that appears above your signature on page 3 is true and correct?
Yes, sir.
Right. And did you also sign where it says plea bargain agreement?
Yes, sir.
And that the waiver of time to file motion for new trial
Yes, sir.
on the trial court's certification of appeal?
Yes, sir.
All right, sir. And let me ask, you said that you were not able to read these documents yourself?
Yes, sir.
All right. Did your attorney, Mr. Flores, or someone else read these documents to you?
Ruben Flores, too.
I'm sorry?
Ruben Flores read them to me.
Okay. And did you understand these documents before you signed them?
Yes, sir.
All right. And are you satisfied with the work that your attorney has done for you?
Yes, sir.
All right, counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
I do, Your Honor.
All right, I'll find that the defendant made his waivers of right and his stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, sir, to the allegation that you violated rule number 17 of your deferred adjudication, of your probation, and by failing to complete required hours of community service restitution. Is that true or not true? Is it true or not true? Okay, so it's true that you violated the rules?
Yes, sir.
All right. I'll accept your plea of true and ask what evidence the state has to substantiate the violation.
Yes, Your Honor. State offers Exhibit 1 and Attachment A.
No objections, Your Honor.
All right, without objection, State's Exhibit 1 is Attachment A are admitted into evidence. Do both sides rest and close at this stage?
State does, Your Honor.
Yes, Your Honor.
All right, I'll find that there is enough evidence to substantiate the violation of the probation and that a change needs to be made in the disposition. And are both sides ready for that hearing?
No, Your Honor. I'd ask that the court give us a reset date so that we may present evidence for the court's consideration.
Okay, well, let me get to the fact that this is an open plea and get that on the record, and then we can reset. So are both sides ready to begin that hearing?
Yes, Your Honor.
All right, so is there a plea bargain agreement in this case other than the plea agreement that Mr. Benavides would plead true to Rule 17?
No, Your
No,
Honor.
there is no agreement as to sentencing.
There's no agreement on punishment.
All right. So you understand, Mr. Benavides, what I'm being told is that you were not able to come to an agreement, you and your attorney, with the state, and that we're simply going to reset this hearing to continue at some time in the future. And that at that time, I'll have to make a decision and I will be able to sentence you to anything from 2 to 10 years confinement, plus order you to pay any unpaid portion of a fine that may have been previously imposed?
Yes, sir.
Okay. All right. How long and is there, I take it there's a request for a pre-sentence investigation?
Yes, Your Honor.
Okay, and how long to get that prepared?
If Ms. Tristan can help us with that date, I don't know how long it'll take.
If you can give us 3 to 4 weeks, Your Honor.
Okay, so if y'all want to confer and pick a date from the,
It would be on your setting, right, Your Honor?
yes.
I see that you would be back April 5th and the 7th.
Either of those dates would work for me, Your Honor.
I don't have a problem with those dates either, Judge.
Okay, and let's just make sure from Ms. Riley that those are my dates on criminal cases.
Yes, sir, they are.
Okay, so let's make it the 5th. All right, so that's 4-05. Sentencing, okay. All right, then I will recess this matter until the 5th of April. Both sides need to be ready to proceed on that day. I'll also order the probation department to prepare a long precedence investigation report.
Thank you, Your Honor.
Yes, Your Honor. Thank you.
Thank you, Judge. I'll post it on chat.
Thank you. All right, and
April what? April 15th?
all right, Mr. Perez, you're back.
Sir, yes, sir. I'm here and ready.
Okay. All right, just to let you know before we get started in a moment. Oh, and Ms. Harkins, I sent that order back to Ms. Benavides. She should have it, or will something else come to me?
Thank you, Your Honor. And Mr. Ramirez is still on and my client, so may we all be excused?
Absolutely.
Okay, and Mr. Ramirez, I will send you the information for the ad litem. Thank you, Judge.
Okay. All right, Mr. Perez, apparently there were two different dates that were given out for first appearances for the indictments last month. One was Wednesday, one was today. One of the folks who appeared today early is Roseanne Perez. The tech share had selected you as the next attorney on the list, and I went ahead and approved that. If you have any uncomfortableness with having a client on a court-appointed case that has the same last name as you do, I'll be glad to move you out. If not, I was just going to ask if you would just get in touch with her, just so y'all can get each other's identification or contact information. And again, she is at the present set for Wednesday.
No problem, sir. That's fine.
All right, and are there any motions or any, I'll let you work on that. Are there any motions or any other written documents I need to look at in the motion to suppress? Oh, and we're going to do Mr. Adams' plea first, so that'll be a few minutes.
Bottom line, Judge, it's a motion to suppress illegal detention. It's a traffic stop that I think is illegal. I filed some other motions, but that's all we need to take up today.
All right, let me get the first part of Benavides filed, and then we'll do the Caffey plea, and then we'll start on the motion to suppress. All right, and do you need a breakout room, Mr. Perez, with your client?
No, sir. We met many times, and he's looking forward to today. So we're.
I mean, Roseanne Perez, your new one.
Oh, yes, that'd be great, actually. Yes, sir.
Okay, because I've got to finish this, and we have one more, please. So.
Yes, that'd be.
I'm going to put y'all in breakout room 8.
Thank you.
All right, Ms. Perez, you should receive a little blue box that you can click on to join that invites you to a private room that you can speak to your attorney in. Okay, and we can start the, oh, Ms. Benavides, I had not hit save. So I'm going to send you 2 copies of that plea package on Benavides. Please do the second one.
Okay.
All right, let me know when Mr. Caffey gets here. I'll be right back.
Your Honor, I believe that's Mr. Caffey.
Okay, my Acrobat's locked up. Give me a moment, see if it heals itself. Okay, are you Gene Scott Caffey?
Yes, I am, Your Honor.
Is that your true and correct name?
Yes, sir.
All right, Mr. Caffey, can you speak, read, and write the English language?
Yes, I can.
And are you a United States citizen?
Yes, I am.
All right, despite your representation that you are a United States citizen, I need to caution you, but if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to go ahead and enter a plea today?
Yes, sir.
All right. Do you have any history of mental health problems?
No, Your Honor.
Counsel, do you believe your client is competent to stand trial?
Yes, Judge.
All right, sir, you stand charged by indictment with, a third-degree felony offense of possession of a controlled substance. Specifically, it's alleged that on or about September the 11th, 2019, in Atascosa County, Texas, you possessed a methamphetamine, a controlled substance, in an amount of 1 gram or more, but less than 4 grams. Okay. All right, and is the state proceeding on its enhancement?
Pardon me, Your Honor. No, Your Honor. State's not proceeding on the enhancement.
All right, sir. And that alleges a third-degree felony. In Texas, a third-degree felony is punishable by confinement for not less than 2 and not more than 10 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, I do, Your Honor.
You understand that the plea bargain agreement you have with the state is not binding on me. I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, Your Honor.
You understand that if I do follow the plea bargain agreement that you have with the state, and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter?
Yes, Your Honor.
All right. I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. I want to ask on paragraph 2.11, is that your signature?
Yes, Your Honor.
And also where it says verification?
Yes, Your Honor.
And do you swear or affirm that everything above where your signature is at verification is true and correct?
Yes, Your Honor.
Okay. And did you also sign at the certification of appeal?
Yes, Your Honor.
Agreed punishment?
Yes, Your Honor.
Waiver of preservation of evidence?
Yes, sir.
And the discovery compliance certificate?
Yes.
All right. Did you read these documents yourself or did Mr. Adams read them to you?
Yes, yes, Your Honor.
Okay. Did you understand these documents before you signed them?
Yes, Your Honor.
And are you satisfied with the work that Mr. Adams has done for you?
Yes, Your Honor.
All right, counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Judge.
All right, sir. Do you also believe that you've received all the discovery you're entitled to in a timely manner?
Yes, we have.
All right, sir. I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeal, and I'll approve them rather. I will also accept the discovery compliance certificate. All right, and I'll ask you, sir, to the allegation in the indictment, third-degree felony possession of a controlled substance, do you plead guilty or not guilty?
No contest, Your Honor.
Okay, and do you understand, sir, that pleading no contest might be different than pleading guilty if you got into a civil lawsuit over what you were doing on the day in question back in 2019?
Yes,
But that for all purposes inside this criminal case, pleading no contest is the same as pleading guilty?
Yes, Your Honor.
All right. Has anyone promised you anything other than your plea bargain with the state to get you to plead no contest?
No, Your Honor.
Has anybody harmed or threatened you or anyone close to you for your plea?
No, Your Honor.
Has anyone promised you an early release from your sentence?
No, Your Honor.
All right, I'll find that you made your plea in this case voluntarily and you're not under any compulsion in making it. I'll accept it. And I'll ask what evidence the state has to substantiate the violation, the defendant's guilt.
State tender, State's Exhibit 1 is attachment A.
No objections.
All right, without objection, State's Exhibit 1 and its attachment A are admitted into evidence. Do both sides rest and close at this stage?
State rest and close.
Defense rest and close, Judge.
Okay, I'll find there is enough evidence to substantiate the defendant's guilt. And I will ask if both sides are ready for sentencing.
State's ready.
Defense is ready.
Okay. All right, is there a pre-sentence investigation or a waiver of one?
Yes, Judge, we waive that.
All right, what is the plea bargain in this case?
Plea bargain in this case, Your Honors, for 3 years in the Texas Department of Criminal Justice Correctional Institutions Division, $315 in court costs with 90 days credit.
All right, sir, you heard what was read in the record by the state's attorney. Is that your agreement with the state?
Yes, Your Honor.
Judge, there's a difference on that credit, though. He's there's a substantially more days than 90 days credit for him.
All right, was he out on probation, on a bond for part of the time, or what happened?
I believe he was in for 90 days, and then he got picked up later on in Bexar County on the warrant out of Atascosa, is my understanding. And he's been, I believe, since August 26th of 2020, he has been in custody either at Bexar County on this matter or here in Atascosa. And then I think he went to TDC actually in November, but then came back. They bench warranted him back.
All right.
Is that right, Mr. Caffey?
That's correct.
All right, Mr. Lamb.
Your Honor, I can double check that in the resubmitted judgment with corrected dates if that is appropriate.
All right, so apart from the discrepancy on time served, is that your plea bargain,
Yes, Your Honor.
Kathy?
And as long as it runs concurrent with my current sentence.
Absolutely. Okay, anything else from either side?
Nothing from the defense other than the credit for time served matter.
Okay, I'll find I have enough evidence to make a decision in this case without a precedence investigation. And I will find the defendant guilty and sentence him to 3 years confinement, with the exception of, just with the understanding that we do not have and the defense do not have an agreement right now on how many days he's entitled to credit for. So it is the order, judgment, decree of the court that you be taken by the, pardon me, I have sentenced you to 3 years confinement. Now, is there any legal reason other than the dispute about the number of days for credit the sentence should not now be imposed?
No, sir.
All right, it is the order, judgment, decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent in the Department of Criminal Justice. Your sentence will be started today. It will run concurrently with any other sentence you may be under, and you will receive credit for all of the time you have spent so far in jail on this charge. Now, there is a dispute about how much that time is right now. So what I will do is I will find that you have waived the right to appeal, with the exception that if you and the state's attorney are not able to work that out and come to an agreement on how many days you're entitled to credit for, if Mr. Adams, within the time allowed for law, files a motion for new trial saying that you can't agree on the number of days you're entitled to credit for, I will grant that. Apart from that, do you understand that because I have followed the plea bargain agreement that you've waived the right to appeal?
Yes, sir.
All right, and I'll find you made your post-trial waivers knowingly, intelligently, and voluntarily. And what I will do is I will sign the waivers right now, and I will hold off on signing the judgment. If we don't have something by the end of the day, I'll sign whatever the state has already prepared, but which I have right here, okay? But I will hold off on signing it right now.
Yes, Your Honor.
All right, so let me get the waivers signed up and I will get those to Ms. Benavides.
Kenny, if you'll check your email in a few minutes, I'm going to send you something, okay?
Okay.
Judge, may I be excused on this one?
Yes, sir, if that's all you have.
Thank you very much.
Okay, I just sent the pre-packet to Ms. Benavides.
I got it, Judge.
All right, anything else before we start Mr. Perez's motion to suppress? Looks like he's still talking to his client. Give me just a moment to return a call and I'll Okay, Mr. Perez, let me look and see. Your client is Ricardo Arreola. If we could get him to the jail.
Yes, sir.
Yes, sir.
Judge, while we're waiting, my new client, Roseanne Pettis, is she good to go until Wednesday?
Yes.
Okay, Ms. Pettis, I'll see you Wednesday, okay? I'll email you the information once I get it.
Thank you, sir. Appreciate it.
Your Honor, I believe Mr. Arreola is at the jail.
All right. All right, calling State versus Ricardo Arreola Jr. Are both sides ready?
Yes, Your Honor, state's ready, but state does have some preliminary matters that it wants to take up with the court before we proceed with the motion itself.
Defense ready.
All right, go ahead, Mr. Lamb.
Your Honor, preliminarily, the state would ask to put the offer on the record. And I believe defense counsel is asking to do it outside the presence of the judge.
Oh, certainly.
That's correct, Your Honor. It would just take a minute.
All right. So what I'm going to do is I'm going to sit here, but I will mute my computer. When I have it muted, I'll make a cross arm like this. Oh, I didn't realize it made the background go away and show the seal behind me. And then after you've had a chance to do that and you're finished and it's been put on the record, everyone's satisfaction, if people will just wave at me, then I will come back. So,
yes, Your Honor.
Any questions?
No, sir.
Okay.
For the record, on case number 20050097 CRA State versus Ricardo Arreola Jr. The state's offer on this case, it is a manufacturing, delivering controlled substance penalty group 1 above 400 grams. The state's offer is to plead to the lesser included of possession of controlled substance PG1 over 400 grams for 10 years in the Texas Department of Criminal Justice Institutions Division. Absent this hearing, if we proceed on this hearing, the state's minimum offer as statutorily required would then be 15 years in the Texas Department of Criminal Justice.
For the record, this is Adrian Bettis. I'm Ricardo Arreola's attorney. Mr. Arreola, good morning.
Morning, sir.
Today is the day of your motion to suppress hearing, the one that we've been waiting for a while.
Yes, sir.
Right now, the judge is not listening to us. It's just the lawyers and the court reporter. We need the court reporter to document everything because this is technically when your trial starts, technically, at least part of it, okay?
Yes, sir.
Today, we are going to argue that the traffic stop was illegal and that the drugs seized should be thrown out of evidence. You remember discussing that with me at the jail multiple times?
Yes, I do.
Okay. And without getting into specifics, because we don't want to show our hand, okay? Without getting into specifics, you and I have discussed our specific strategy and arguments for today. Yes?
Yes, sir.
And you and I have come to, for lack of a better word, an agreement as to how we're going to proceed today from the defense perspective, correct? Okay. We've also discussed that after today, the state likely will pull their offer of 10 years TDCJ on a simple possession charge, correct?
Yep.
And not trying to change your mind. You've had enough time to think about that, and you're comfortable rejecting this charge and moving forward with what we discussed we were going to do today, correct?
Yes, sir. Yes, I am.
Okay. Mr. Lamb, I think that's sufficient for me. Is that sufficient for you?
Yes, that is.
Okay. Mr. Arreola, we're going to get started. I'm going to get right down into it as long as you don't need to talk to me privately, okay?
No, I'm good. I'm set to go.
Okay. All right. Kenny, if you want to let the judge know.
Yeah, we're just going to wave the judge down.
Okay. Thanks.
Okay, I'm back.
So that okay, that portion is done, Your Honor. Secondly, my troopers here on the Zoom under Trooper Gonzalez, I know that he had a laptop that he also had. Should have been an LG number that's in a breakout room. Is there any way that we can have him bring that back into the general room so that when we play the video, he can see it?
Okay, I just hit move to main session. Let's see if that happens. I think he's,
There it goes.
there it goes, okay. All right. So what all witnesses does each side have?
State has Trooper Gonzalez as our sole witness.
No witnesses for the defense.
All right, Trooper Gonzalez, will you raise your right hand? Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and your full name?
Luis Gonzalez. Luisgonzalez.
Okay, with a Z, all righty. And Mr. Perez, do I have a copy of your motion?
You should, yes, sir. If not, I'll send you one.
I mean, if you just post that to me in chat, I'd appreciate it. Anything else, Mr. Lamb?
Yes, Your Honor. And then once the motion's been submitted to chat, the state would ask the court to limit today's hearing to the traffic stop as the discussion with Mr. Bettis earlier. I believe the motion itself was a pretty general motion.
That's the only thing we're gonna contest, at least at this time, Judge. I'm posting it right now in chat.
All right, I'll just let you make your objections as to scope or relevance to this hearing as you go along, sir. Mr. Lamb and Mr. Perez.
Yes, Your Honor.
It should be there posted for you, sir.
Okay, I'm trying to. Okay. All right. So is the state stipulating that the arrest arose out of, it was warrantless and arose out of a traffic stop?
Yes, Your Honor.
All right, so does the state want to go first then, or?
Yeah, the state will proceed first.
All right, go ahead.
State calls Trooper Gonzalez.
Yes, sir.
Trooper Gonzalez, how are you currently employed?
Currently employed with the Texas DPS, Texas Department of Public Safety. I'm currently a canine handler. I've been with DPS going on 8 years, sir.
Sorry for any feedback or anything like that. If I accidentally cut you off at any point, Zoom has had some issues, so you may hear me a little bit delayed. Same thing with Mr. Bettis or the judge. If at any point I cut you off or anything like that, let me know and we can continue with the questioning or have you finish your answer. You okay with that?
Yes, sir. Yes, sir. I'm okay with that.
And so you said that you've been with DPS for how long?
Going on 8 years, sir. So come this June of this year will be 8 years.
Okay. And I know I almost cut you off a little bit. You said you're a canine handler?
Yes, sir. I'm currently a canine handler and I'm stationed in Alice down in Jim Wills County. That is my duties for the department.
Okay. And for how did you become a trooper?
Basically, I filled out my application December of 2013, got hired, went to the academy, and basically, once you're there for 23 weeks and you go through the whole course before you actually get commissioned. You
okay.
learn.
You said the academy.
Mr. Lamb, Judge, I'm sorry. Before we proceed further, I did need to make Mr. Lamb aware of something. I'm sorry for interrupting you, Kenny. The scope of this actually would go to the search as well. It was a consent search, but I'd like to have that covered as well, Mr. Lamb. I wanted to let you know that way you had time to make sure that you discuss that with Trooper Gonzalez. I'm sorry for the interruption, Judge.
Go ahead.
Your Honor, if I may have a brief moment then.
All right. Do you need a breakout room?
Yes, please. If you could allow for Trooper Gonzalez and for the LG 17.
Okay, I've been giving you all an invitation to number 6. And I will be here.
Your Honor.
Okay, go ahead.
State's ready to proceed.
Go ahead.
Okay. Mr. Trooper, we left off with, sorry, Trooper Gonzalez, we left off with discussing about your training. You said that you went to the academy?
Yes, sir, that's correct. So basically at the academy, we're there for 23 weeks and we learn traffic enforcement, crash investigation, penal code, use of force, things like that.
And so you went through all the training there, and that was back in 2013, you said, or 2014?
2013, December 2013.
Okay.
That's when I went out there.
Now, after that, have you received any additional training?
So basically, once we graduate and we get commissioned, we still have other trainings that that we got to keep up with. Things that are regulated by DPS. So when we graduate, we basically just have a level 1 crash investigation. So pretty much about 6 months to a year after you graduate, you go to level 2 crash school, where we learn additional information when it comes to crash investigation. And of course, we got to do like additional DWI stuff where you get your toxilizer certificate and things like that.
And when you say crash school, does that also include the regular, or not regular, but does that include traffic violations? Do you get training on all the traffic violations in the state of Texas?
Yes, sir. So all that, the traffic code is learned in the academy. And of course, we have in-service where we fresh up on additional information that comes out on maybe recent House bills or things like that. But for the most part, we're always doing some sort of training.
Okay. And would that crash training and that training allow you to identify traffic violations such as following too closely?
Yes, sir. That is correct. Level 1 and level 2 crash school, we learn perception reaction times, which are very important, to avoid potential crashes. Following distances on the highway, are basically things that we always enforce. They're following too closely, they can possibly get in a crash.
Okay. So now you've been with Texas DPS since 2013, correct?
So I graduated in June of 2014, started December 13th. So technically my commission was in June 14. So I'm going on 8 years.
Okay. Now, were you working January 16th of 2020?
Yes, sir, I was.
And where were you stationed at that time, or where were you working out of?
So I was working out of I was still assigned in Jim Wills County. And that particular day I was working on Interstate 37 in Atascosa County.
Okay. And do you recognize a defendant by the name of Ricardo Arreola Jr.?
Yes, sir, I do.
And on our screen, are you able to recognize a person by Ricardo Arreola Jr.?
I saw him earlier. I do recognize him. Yes, sir.
Okay. And you said that you saw him earlier. Is there any way that you can?
So I saw him on the screen, but for some reason I'm not seeing him on my phone anymore. But I did recognize Mr. Arreola.
Your Honor, for the purposes of Zoom, Trooper, do you see a person on the screen right now?
Yes, sir. I see Mr. Ricardo Arreola.
Okay, and for the record, could you identify him by an article of clothing?
He's wearing a orange suit.
Okay. Now, on January 16th of 2020, you said that you were working in Atascosa County. Do you remember what was going on that day?
Yes, sir. Region 6 was basically working up there with various troopers from other districts. And I was basically requested to go and assist them for basic traffic enforcement, just in case they ever needed a canine and stuff like that.
Okay.
So we're very limited within the state. So it's something that we tend to do from time to time.
Okay. Now, on that day, did you, at approximately 12:47 p.m., did you make a traffic stop?
Yes, sir. A traffic stop was done on Mr. Ariola.
Okay. And do you remember what happened during that traffic stop?
Traffic stop was conducted on Mr. Ariola on Interstate 37, northbound in Atascosa, for a traffic violation, which was following too closely. Traffic stop resulted in the discovery of, what was it, 2 kilograms of suspected cocaine.
Okay. Now, we're gonna, for the purposes of this motion to suppress, we're gonna be talking about that traffic stop. You stated that the defendant was following too closely.
Yes, sir. He was following too closely to a commercial motor vehicle. If I remember correctly, it was a tanker.
Okay. Now, is your vehicle equipped with dash cam?
Yes, sir. It is equipped with the watch guard system.
And was it taking video that day?
Yes, sir.
And did we previously review a video of that traffic stop?
Yes, we reviewed the video before.
And was it a fair and accurate representation of what happened that day?
Sure is. Yes, sir.
And had it been altered or changed in any way?
Not at all.
Your Honor, am I allowed to share a screen?
Yes.
This should be showing everybody a video at this point.
Yes, I see it.
Okay. Your Honor, state would tender as State's Exhibit 1 for the purposes of this hearing, the video in the traffic stop for Ricardo Ariola.
No objection.
Without objection, State's Exhibit 1 is admitted into evidence. Go ahead, sir.
Now, Trooper Gonzalez, was this the day in which you stopped Mr. Ariola?
Yes, sir. That is the video. Yes, sir.
Okay. Now, for the purposes of this hearing, usually in court, we'd be able to have you point and show what you're looking at. I will be doing that with my mouse and my cursor. If there's anything at all that you need me to show the court specifically, please let me know so that I can reference it with my cursor. Are we okay with that?
Yes, sir.
Okay. So can you describe to us what's going on at this point in the video?
So at this point, the Pontiac passenger car, the blue car, is being driven by Mr. Ariola. He's currently traveling on Interstate 37 northbound in Atascosa County.
Okay. I'm going to start playing the video. I'm going to stop the video at 30 seconds here, and the traffic violation happens in a little bit. And I just want to kind of get some facts out there first as to how you determine that there is a traffic violation that happens. So what's going on right now? Can you tell us what's going on and how you use certain information to determine that there was a traffic violation happening?
Okay, so basically, right about now, Mr. Ariola, he's not really using his cruise control. His speed does begin to vary. You know, he traveled anywhere from, I want to say it was, I think, 73 miles an hour, between 69 and 73 miles an hour is roughly what his travel speed was. Commercial motor vehicles, typically they do drive a lot slower. I mean, 60 to 65 is about the average. As we can see from the beginning of the video, he's beginning to close the gap, meaning that he's starting to get closer to this commercial motor vehicle. And the white truck.
Trooper, I'm going to stop you for one quick second there. When you say commercial vehicle, are you talking about this tanker that's in front of him?
Yes, sir, the tanker.
Okay. Now, continue.
So basically, as you can tell, both vehicles, the white one, which we're not concerned about the white truck, the white car, the white truck and the blue car are beginning to get closer to this commercial motor vehicle, the tanker. So basically, we know that they are traveling faster than the actual truck. So what I'm looking at right now is the violation. Well, actually, I'll explain it once we get closer to it. But in order for us to articulate the following too closely is we have to factor in perception and reaction time. So perception is basically the time that it takes for a person to perceive and see a potential hazard on the roadway.
And does DPS have a standard in which you guys go by?
Yes, sir.
And what's that standard?
So the perception itself is 0.75 seconds. That is for the average motorist. We also have, in addition to the 0.75, we have to add another 0.75 for the actual reaction time. So we have the perception from the time you see it, plus the reaction time, 0.75 to the time you actually react. So that's 1.5 seconds before the driver even applies his brakes.
Okay. And how does that factor into a following too closely? Why does it factor in?
So it is very important when it comes to following too closely is if you're too close, you're basically gonna crash. Because the person in front of you might potentially brake, take some sort of evasive action because there might be a tire on the roadway, animal runs across the highway, something can happen. So therefore, the following too closely is extremely important to avoid a possible collision.
Okay. And do you use any other factors around the road to help you determine if somebody is following too closely?
That's my mouth.
Yes, sir. So the white lines that you're seeing on the highway, the lanes on the highway, I don't know why I have a habit of trying to point to it. The white lines are
super.
I just have like
hold on for 1 second.
Just a moment, just a moment.
Okay, I can get on.
Yeah, Mrs. Riley, I think that you're.
Sorry, Judge.
All right. Go ahead, sir.
Okay. Sorry for that. Could we go back? You said that you use the white lines?
Yes, sir. So the center stripes on the highway, those each one of those white lines is 10 feet.
Okay.
And they are separated by 30 feet.
Okay.
So that's our reference point on the highway. We could actually use signs as well, or basically anything that can stand out on the highway. We can use that as a reference. And like I said, going back to the perception reaction time, it takes 1.5 seconds for the average person to apply their brakes. Once once they've already witnessed the possible hazard and actually take the action.
Okay. And you stated that the defendant in this case was traveling between 69 and 73 miles per hour, right?
Yes, sir.
What would be the general distance in which somebody would need to be to not be following too closely or not have an accident?
So basically what we have to do is we have to convert the miles per hour into velocity, feet per second. So in this case, we would take 69 miles an hour times 1.466. Okay, so that gives us a total of 101 feet. Now we do that times the reaction time gives us 151. So we're going to go ahead and utilize 150 feet. That is the minimum required distance for a vehicle traveling at 69 miles an hour to begin to start braking.
Okay, and how much, I guess, as a general reference for that, how far would that be in regards to these markers?
So you're looking at roughly 4 markers.
Okay. And so your vehicle is traveling farther away from Mr. Arriola's vehicle in this case, correct?
Correct, sir.
Okay. So those are some of the factors that you use to determine if somebody is following too closely.
Yes, sir.
Okay, now I'm going to continue playing the video and we'll stop the video when it gets to that point where the traffic violations occurred. So I'm going to start the video at 30 seconds. Okay. So Trooper, I know that we've gone over this video and we've kind of discussed this.
Yes, sir.
I'm going to rewind this up back to this 45 seconds, right to where his vehicle is making the curve. Can you explain to us what you were seeing that day?
Okay, so approaching the curve, right about where when he's entering this particular curve, he's not 100% too close right there, but he continues to gain distance, meaning he continues to close the gap on this truck tractor or the tanker.
And
So 150 feet is roughly 15 cars. Just to give you an idea and put it into a simple term, roughly 15 cars should be in front of him and behind a truck tractor.
And so at this point, they're going around this curve right here. As he approaches this point at about 1 minute and 2 seconds, I know that we had discussed this before. He is now crossing the lane right here, correct?
Right. Yeah, he's basically changing lanes at the last minute. I mean, if you look at I can't move my cursor to kind of show you, but basically the first center stripe you see on the highway, he had enough time to change lanes way before that. But in this case, he waited too long and followed too closely.
Okay. And
before he made the lane change.
And the following too closely you're describing is that his back bumper to the front bumper of the vehicle, the back bumper of the tanker and the front bumper of his vehicle, correct?
Yes, sir. That should have been a minimum of 150 feet.
And at this
in order
point,
for him to avoid a collision.
And at this point, at about the 1 minute and 1 second, 1 minute and 2 second marker, he was within that following too closely range, correct?
Correct.
And this would be from your experience and your training, this is too close to that tanker.
Yes, sir. Just from, enforcing traffic laws for the last, 7.5 years and working numerous crashes. A lot of times this is a contributing factor. I estimated he was traveling roughly 60 feet instead of 150.
Okay, and that would be within that range. And I know that we had discussed this prior as well. There was the white vehicle that was traveling next to him right here. Did that help you in referencing how close he was to the tanker at any point?
Yes and no, sir. Basically, I mainly relied on basically looking at the actual roadway and him closing the gap within the truck tractor.
Okay. Are we still sharing the screen, Your Honor? Or
I didn't stop it.
Oh no, I stopped it, Your Honor. I just wanted to make sure. And so at that point in the video, you stated that he was following too closely. What did you do after that?
I conducted a traffic stop for a traffic violation and made contact with Mr. Ariola.
Okay. And Your Honor, if I may have a brief moment to fast forward the video.
Go ahead. Well, why don't we do this since they're unrelated? I mean, in that they're different fact patterns, different issues. Why don't we do this one step at a time? One was the stop. The other is whether it was or was not valid consent for search.
Yes, Your Honor.
If you're still on the stop, that's great.
No, Your Honor, I passed the witness based on the stop itself.
All right, Mr. Perez.
Hi, Trooper Gonzalez. I'm Adrian Pettis. I'm just going to ask you a few questions. At the time that you pulled over Mr. Ariola, how long had you been on the police force or a law enforcement officer?
That time, I was about 6.5 years.
Okay.
A little longer than that. Sorry,
And during that time, I presume that you've written countless offense reports, correct?
Yes, sir. I have, sir.
Okay. Is it fair to say that in your training, you're taught that it's very important to include all relevant facts in your police report?
Yes, sir, that is correct.
Is that something that you routinely do?
Yes, sir, I always put facts on all my reports.
Okay. Let's talk about some of those facts, okay? Now, is it fair to say that when you first observed Mr. Rayola, you were actually stationary in the center median near mile marker 90?
I know I was stationary. I wouldn't be able to tell you the mile marker.
Okay, but you were stationary, you were not moving, you were patrolling traffic, is that right?
Yes, sir. I was working traffic.
Okay. Is it fair to say when you first noticed Mr. Rayola, you noted in your report that he began to slow down to the point where other motorists were beginning to pass him? Do you remember putting that in your report?
Yes, sir, I did put that on my report.
Okay. Did you also write that Mr. Rayola began to self-soothe by touching his hair?
Yes, I did put
And
that.
Additionally, you wrote that Mr. Areola began to stare towards the east into the brushy area. Is that correct?
That is correct. Yes, sir.
Now, you found that behavior unusual?
Yes, sir. Not necessarily 100% unusual to the point. I'm not sure if I need to elaborate or are you going to continue the question? Finish the question so I can respond.
I'll ask the questions, Trooper, and then if Mr. Lamb has follow-up, I'm sure he'll take care of that.
Okay.
But you wrote those facts into your report, correct?
Yeah, I would like to talk about the last one because I'm not sure if you were going to elaborate on it or not, sir.
What's relevant as far as you saw him staring towards the east into the brushy area?
The very last question that you had asked, I don't know if you were done. So I wanted to see if you were done with it so I could answer the final question, sir.
Go ahead, proceed.
No, I'm saying I didn't hear your whole question. I didn't know because you were asking one at a time. So I don't know if you had something to add to it.
What I was asking you is you noted these items in your report because you felt they were relevant, correct?
Yes, sir. Yes, sir. That's correct.
And they were relevant to you because why?
I've attended numerous trainings, sir. Whenever we have certain stimulus on the highway, the patrol car could potentially create fear to certain motorists. And whenever we typically see those things, there is a possibility that something can be afoot. Sometimes a person doesn't have a driver's license. Sometimes they have warrants, or sometimes they're doing some things that they're not supposed to be doing. This is called a proxemics exchange. Things that I've learned through going to DIAP conference, Cincinnati, Ohio, and I took in other classes pertaining to criminal interdiction. Mr. Arreola, as he drove past my car, he displayed some driving behavior, whereas other motorists, and I'm talking hundreds that go by, did not react to my patrol car like he did.
So in other words, Mr. Areola's behavior caused you to be suspicious of him? Correct?
Well, not 100% suspicious. We still have to have probable cause to conduct a traffic stop.
Well, his behavior caused you to pull out from your stationary position and follow him, correct?
Yes, sir.
Okay. Now, you also noted that you observed Mr. Areola to be driving 69 miles an hour in a 75 mile an hour zone, correct?
Yes, sir. That was, I'm not 100% sure of his original speed, but meaning prior to him beginning to slow down and seeing my patrol car, I wouldn't be able to tell you that speed, but 69 miles an hour, yes, sir.
Would it help you if I showed you your offense report?
No, I do remember, and I did tell Mr. Lamb that he was traveling at 69 miles an hour. His speed did vary. What I was saying is I don't know how fast he was going prior to him seeing my car because the car on the highway created a stimulus where he began to slow down and other cars had to pass him.
Mr. Areola was going under the posted speed limit the entire time of your encounter. Is that correct?
Yes, he was. Yes, sir.
Is it fair to say that you also put in your report that you felt Mr. Areola was being overly cautious?
Yes, he was being overly cautious.
So then you state that Mr. Areola's speed began to vary between 69 miles an hour and 74 miles an hour, correct?
Yes, sir, that is correct.
Okay. It's fair at this point that you believe that criminal activity is afoot?
No, sir, not 100%.
Okay. Now, when we say not 100%, I'm not asking you 100%. I'm asking you, did you suspect Mr. Areola of possibly being involved in criminal activity?
No, sir, I did not suspect that. I did suspect that he was being way too cautious to the point where other motorists just continued to go by. So therefore, he caught my attention. I cannot assume that he was up to no good without actually making contact with him, if that makes any sense.
Well, you assumed enough that you figured you needed to follow him. Is that correct?
We in law enforcement, I mean, we always do that, sir.
Oh, okay. Well, the thing is we're getting into a play on words, and I'm not trying to be difficult with you, but you put these facts in your report. You said that you put facts in your report when they're important. So here I'm presuming that these facts are important, correct?
Yes, sir, they are important. It's just the way you had asked me kind of confused me for a little bit.
Okay. Now, you mentioned that the driver, that Mr. Areola began to follow the commercial vehicle too slowly. Is that correct?
Too slowly?
I'm sorry, too closely.
Yes, sir, he did.
And you put in your report that you actually stopped him for following too closely, and then you cited the Texas Transportation Code statute in your report. Do you recall that?
I recall putting it, yes, sir.
Okay. Are you familiar with that statute?
I mean, I don't know it verbatim, but yes, sir, I am familiar with it.
Okay. Would it help if I showed you a copy of that statute so you'd have the verbatim language?
Sure.
Okay. And Judge, pending any objection from Mr. Lamb, I'm posting it in chat. This is the verbatim language of the following too closely statute from the Texas Transportation Code. I'm not offering this into evidence, but I'm just offering it so that way the trooper could refresh his memory and be aware of the actual language in the statute.
Okay.
Trooper, did you receive the item I posted in chat?
Let me move my computer. I'm working off my phone and my PC, so give me just a minute, sir.
Okay.
It appears I got it downloaded.
Okay. Well, while you're doing that, do you mind downloading that and I'll just continue with my question?
Yeah, you can continue on, sir.
Okay. You had mentioned that in making your evaluation or your decision that Mr. Areola was following too closely, that you were using certain clues on the roadway and around the roadway, correct?
Yes, sir, that's correct.
You mentioned the white lines and the space separating the white lines, correct?
Yes, sir.
Okay. You also stated that generally, altogether, in the perception and reaction time is generally around 1.5 seconds, correct?
Yes, sir, that's correct.
And I understood that to be when a motorist observes the need to brake or the need to avoid striking something in front of them, it would take about 1.5 seconds in order to begin to do so. Is that correct?
To begin braking, that's correct.
Okay. And then we had, you and Mr. Lamb had started discussing some numbers that frankly appeared to be pretty confusing to me. You mentioned that you have to convert miles per hour in velocity, feet per second, et cetera. You remember discussing that with Mr. Lamb?
Yes, sir.
Okay. And that seems like a rather complicated formula. Can you explain that to me again, generally?
So basically, we would take the speed of the vehicle. So like I said, it was 69. times 1.466. It gives us 101. And then we take the reaction time, perception reaction time, 1.5 seconds. It's 151 feet. In this case, 150 feet. We actually have an example when we go to crash investigation, level 1, level 2. It's in our manual. Something that's relatively easy for me to remember. As far as that, the example for this particular topic.
Okay, so it's 69 miles per hour, or it's the vehicle speed times the perception and reaction time. Is that right?
No, it is. We have to convert it into feet per second. So it's 69 times 1.466. And then once we get that 101 feet, then we times it times 1.5. That gives us the minimum required distance, meaning it'd be 151 feet before the subject hits his brakes.
Okay. Now, how do you do that? Do you have a calculator, or do you plug something into your computer while you're driving, or does your car do it for you? How do you calculate all that?
So once again, it's part of my manual, sir. It's part of one of the examples on my manual. So it's just something that I basically remember. So just to give you the example that's utilized on my manual is a vehicle that's traveling at 70 miles an hour. So it would be 153 feet for a car going 70. So I did do the math, and I knew that it was going to be less than 153 feet. It wasn't going to be that much. And after doing the math, it's 151 feet.
Okay,
But
well,
I had
that's
narrowed it down to 150.
okay. And you did that when you were following Mr. Aola in your car?
I once again, sir, it's on my manual. I remembered it. I confirmed it, but I wasn't there trying to plug in numbers, if that makes sense, because it's on my manual.
Well, it's on your manual, but I guess the point that I'm getting at is when you decided to pull over Mr. Aola for following too closely, it's fair to say that you did not perform this calculation, right?
It's something that I remember, sir. I mean, I don't know what to tell you.
That's not what I'm asking you. What I'm asking you is you gave Mr. Lamb this big, complicated formula to determine whether or not somebody is following too closely. You had mentioned that they they teach you to do this in the academy, that it's in your manual, that it's a calculation that you have to do, that you have to convert it to feet. And you spent all this time saying how important this is, and then you're telling this court that you did not do that when you decided that Mr. Aola was following too closely. Is that right?
I actually gave your defendant the benefit of the doubt, sir, because once again—
That's not what, Judge, I'm going to object to non-responsive. I'm going to ask the court to instruct the witness to answer the question whether or not he did this calculation prior to pulling over Mr. Aola.
Trooper Gonzalez, just answer the question that's put to you. If the answer is yes, but, or something like that, then Mr. Lamb will have an opportunity, if he wants to follow up with you, to ask what else he wanted to say, if there was something else.
The trooper, I'll ask you again, did you do this calculation prior to pulling over Mr. Aola?
I did not do the full calculation, sir, the full math on it. What I did was 69 times 1.5 seconds, which is way below the amount that needs to be the distance that needs to be maintained, if that makes any sense.
Okay, now I'm a little bit confused because a few minutes ago, you specifically stated that you did not do the calculation. You said it's in my manual. I did not do the calculation. Now you're telling me that you partially did the calculation. So which one is it?
What I did is I gauged it utilizing the 1.5 seconds times the speed of the vehicle. That is not the proper formula.
So
the proper formula is what I explained to you, sir.
Okay, so you pulled Mr. Aola over for following too closely using an improper formula.
I didn't do the math, sir. I don't know how else to explain to you. I have it on my manual at 70 miles an hour. I've been doing this for quite a while. A lot of this is already in my head. So it's for me to do the math while I'm driving, it's very difficult. Things that I remember, sir.
Okay. Now, have you had time for the attachment that I sent you to download?
Yes, I see it now, sir.
Okay. You don't have to read it verbatim, but just looking at it, can you tell me where in this statute it states that a person is driving, is following too close whenever their velocity, their speed times the perception and reaction time exceeds the 150 feet? Does it
You will
say
not.
that in the statute?
No, sir, you won't see that on the law.
And in fact, the law doesn't give any numbers whatsoever as to what constitutes too close, right?
We have our basically during our crash investigation, this is what's taught: perception, reaction time. This is standard. So no, it's not written in law. This is the way I was trained. This is what I've learned in crash investigation.
In fact, the law states that an operator will maintain a clear distance between two vehicles so that, considering the speed of the vehicles, traffic, and other conditions of the highway, the operator can safely stop without colliding with the preceding vehicle. That's essentially what the statute says, right?
Yes, sir.
Okay. Now let me ask you this. You had mentioned that Mr. Areola was going under the speed limit at all times, correct?
Yes, sir. He was not.
In fact, your words were Mr. Areola was being overly cautious. Is that correct?
Yes, sir.
And also from this video, it looks like there's very, very light traffic during this encounter, correct?
There is light traffic, and like I told Mr. Lamb, Mr. Areola had ample time to change lanes instead of getting too close to the tanker. So by being too cautious, that's exactly what I meant. And
then also, we don't see anything in the video giving any indication that the conditions of the highway was unsafe, right? We don't see rain, we don't see snow, we don't see ice, correct?
There is a curve and slight hill crest. So yes, anything can happen, sir.
But we don't see any weather conditions, right?
Road conditions and weather conditions can be a factor. It doesn't necessarily have to be raining or snowing. I did say there's a hill crest, sir, and a curve. He had enough time to change lanes.
Well, I mean, I understand that, but do you see any conditions that are, you would agree with me that we don't see any conditions that would not be typical pretty much on any roadway in the state of Texas, right?
I would not agree with that, sir. When you're going through a hill crest and a curve, there could be maybe somebody drops some debris on the highway. There's always some sort of possible danger on the highway, sir.
Okay. Can you tell me in your report where you put that you felt that the hill crest and the curve was a condition that you believed was dangerous to Mr. Areola?
I do not know if I 100% put it on there, sir.
Would you agree with me that if I told you you did not put that on there, right?
Yeah, well, I know you wouldn't lie like that, so I would agree that.
And would you agree? And earlier you testified that if something is important, that you would put it in your report because you've been in a law enforcement officer for roughly 6.5 years at this point. You've done numerous police reports, and you're trained to put every relevant fact into your report, correct?
In this case, I didn't put it, but it is relevant.
Well, it would stand to reason that if you didn't put it, it's not relevant because you just told this court that you put all relevant facts in your report, and here it's not in here, right?
I did not put it on there, sir.
Okay. Is it fair to say that when you saw Mr. Areola, you had already suspected him of drug trafficking and you were already going to pull him over no matter what? Is that fair to say?
No, sir. 100% no, sir.
Let's fast forward just a little bit here. According to my notes, now I'll ask Mr. Lamb if he doesn't mind, if necessary for you to replay the video. Otherwise, I'll try to stumble through this. But would you agree with me that after, well, let me figure out how I'm going to ask you this. Would you agree with me if I told you that roughly 18 minutes elapsed from not the time of the traffic stop, But the time that I'm sorry, Judge. Let me rephrase.
Your Honor, Mr. Bettis, are you getting into the
Yes,
issue of
yes,
consent?
yes. We're going to come back to that. Correct?
Yeah.
Yeah,
I'm sorry. Let me retract that question, Your Honor. Mr. Lamb, do you mind queuing up that video? Otherwise, so I'm not keeping the court waiting for it. Mr. Lamb, do you mind go ahead and playing it for me? Actually, this is, I'm sorry, just pause right here for a second. Trooper Gonzalez, this black vehicle is Mr. Ayola's vehicle, correct? Trooper, are you there? You're on mute, sir.
Oh, I had to charge my phone. Can you hear me now, sir?
Yes, sir. Is this black vehicle Mr. Ayola's vehicle?
Yes, sir. That's his car.
Okay. Now, you had mentioned at this point right now, you do not believe that he's following too closely at this particular moment, correct?
Correct, sir.
And right now you're at a bend, so you have, it's fair to say that you have clear sight of the white markers and the space between them, correct?
Yes, sir.
And would you agree with me that you have that clear sight of those items because of the bend in the road specifically? You're able to see the lines unobstructed and correct?
Yeah, so like right now, I'm probably roughly about 160 feet away from Mr. Areola. But he does begin to close the gap on the commercial motor vehicle, essentially following too closely.
But right now he's not too closely at this particular moment, right?
He's no, sir.
And you could tell that because you're able to see the lines and the space between them, correct?
Yes, sir.
And you're able to see the lines and the space between them because of the curve in the road, correct?
Yes, sir. I had him. My actual view from the patrol car, I was able to tell.
Okay. Mr. Lamb, can you press play, please? So go ahead and stop, Mr. Lamb. Trooper, at some point in between where we started and now is where you allege Mr. Areola was following too closely, correct?
Yes, sir.
And is it fair to say that you made that decision because you, well, let me back up. In making the decision, you stated that you use clues that you have on the roadway or around the roadway, correct?
Yes, sir.
Specifically signs or the white lines or the distance in between the white lines, correct?
That's correct.
Okay, and that's what you used here?
Yes, sir.
Okay, now, how would you be able to see the white lines when you're behind Mr. Areola by 150 feet and there's no curve in the road at this point? You're traveling straight. How would you be able to see how many white lines are in between Mr. Areola and the tanker?
Basically, as I'm looking, sir, as you can see the car, when he changes lanes, I knew that 150 feet at his speed is roughly 15 cars. As soon as from the moment that Mr. Areola changed lanes, I looked at it and I was able to see what I estimated approximately 60 feet when he actually changed lanes. He realizes because he's watching me through the mirrors, he does such a slow lane change that essentially he's reducing the speed as he's changing lanes, but he's not really braking. So he's letting go of the gas. So I can actually tell that he is not within 150 feet. I estimated roughly 60 feet.
Okay, so you state that Mr. Areola at this particular point is not following too closely, and you're stating that is so because he has slowed down. Is that correct?
No, sir, I did not say that.
Okay. Well, you stated that Mr. Areola has slowed down at this point, right?
No, sir. As he's changing lanes, if you play the video really slow. He's taking quite a while to actually make the full lane change, is what I mean. So when he actually starts initiating, meaning moving the wheel towards the left to make basically change over the inside lane, he was roughly about 60 feet. Now he begins to slow down. He lets go of the gas. I don't know if he was panicking or what the deal was, or maybe he's just looking at the mirrors, but he actually begins to delay his full movement to proceed to the inside lane. He was not within 150 feet. I can visualize as he's moving that there was no way that roughly 15 cars will fit between the front bumper of his vehicle and the rear bumper of the tanker.
That's based off of your view of this incident, correct?
Yes, sir. That is based on my view, based on my experience in working crashes, and based on my experience in learning formulas and stuff like that.
Now, you had mentioned a word, I believe a very important word earlier. And I believe that word was perception. Can you tell me what that means?
So the perception is basically from the time that the driver, the motorist, perceives potential danger.
Okay. Now, you use perception too while you're driving. Is that correct?
We all do. Yes, sir.
We all do. And is your perception of, well, anybody's perception, is anybody's perception affected by distance?
Perception affected by distance. What are you trying to ask? So I'm not confused, sir.
Well, what I'm trying to ask you is that you had mentioned that we all have this thing called perception, and perception affects how we see things and how we react to things. And here you're saying that Mr. Areola is following too closely because you believe that he cannot fit 15 cars or whatever number of cars you mentioned here. And I'm wondering exactly how you could perceive that when you're 150 feet away and you're driving straight behind him. And I'm wondering how you could be so sure that the 15 cars can't fit in there when all of our observations are affected by perception.
Well, sir, like I explained, as soon as he begins to move the vehicle towards the left and change the lanes, I can clearly see that there is no 150 feet, no 15 cars can fit on there. I estimated roughly 60 feet, sir.
I'll pass the witness.
Mr. Lamb?
Yes, Your Honor. So, Trooper, to go back to, I guess, initially what Mr. Bettis had sent to the judge, the specific code for the following distance. On that, it specifically states an operator shall, if following another vehicle, maintain an assured clear distance between the two vehicles so that, considering the speed of the vehicles, traffic, and the conditions of the highway, the operator can safely stop without colliding with the preceding vehicle. Is that the correct wording that Mr. Bettis gave us?
Yes, sir, that is the correct wording.
Now, that being the case, all of the indicators and everything that you were discussing with the court prior fall into that description of following too closely, correct? Or the following distance?
100%, yes, sir.
And how does that work? Why does that follow the law exactly?
Because it ultimately explains that basically the following distance, how important it is, when you factor into perception reaction time, essentially you avoid a collision by not following too closely. And these formulas are, even though they're not into law, technically, whenever we reconstruct a crash, ultimately a certain crash would never happen had this person followed the statute. The math is just basically to prove what basically was suspected, if that makes sense.
And so when you're talking about these formulas that and you've been trained on, that you use to help you reconstruct or to help you understand what's going on with the person potentially following too closely, with those formulas, what do you use them exactly and do the math on the spot?
whenever we're actually out there reconstructing a crash scene, meaning that, it's a controlled environment, we're able to 100% basically reconstruct a crash and do all the math. As I explained to, I'm sorry about that. As I explained to Mr. Arriola's defense attorney, these are manuals that we're taught. Went to level 1, level 2 crash school. The average speed limit on the highway is 75. This is something that's embedded in my head. As far as the actual formula, the distance. So even though I didn't 100% do the math on the highway, it is part of an example where I have it on my manual, and I wish I could show you, where it says a vehicle is traveling at 70 miles an hour, approximately how many feet, with the motors travel, et cetera. And it gives you the whole breakdown of it. And that is how I utilize this. 69 miles an hour, 70 miles an hour, it's very common on the highway. The defendant was too close. In this case, 150 feet, I estimated roughly 60. As soon as he changes lanes, I can see that there was no way he was within 150 feet, no way 15 cars can fit in there. Therefore, I believe that he could have possibly caused a collision.
Okay.
Again, we got
So just to kind of narrow that back down, you have had these formulas trained and embedded into you. You know what these formulas are. You know what the numbers amount to, correct?
Yes, sir.
And so on a day-to-day basis, you're able to use those references to kind of gauge what's going on, correct?
Yes, sir. This is it's very common because, like I said, the speed. It's just something that we look for. You got the formula, and then at the end of the day, we're trying to reduce crashes because, like I said, there could be something on the roadway, and a truck tractor could have maybe tried to upsee a tire, whatever the case is, and Riola can rear end the truck tractor.
Okay, and that's
He
what
he had enough time to change lanes, and as you were able to see on the video, he waited to the last minute to change lanes, ultimately resulting in falling too close.
Okay, and that's what you use, and those are the references that you use.
Yes, sir.
Okay, and just to bring up the video one more time. Mr. Bettis was talking about perception, but in this portion of the video, when you're looking right here, this is right before, or Mr. Arriola's vehicle was in your same lane right before this moment, correct?
Yes, sir.
And this is when he's changing lanes, and this is when you can use that as a reference as to how far he is from the vehicle in front of him.
Yes, sir.
And once again, in your perception and on that day, what was the distance between them?
Roughly about 60 feet.
And would that be through your training and experience and the speed limit in which he was going at, would that constitute following too closely?
Yes, sir. Right now, my patrol car is roughly 150 feet from the defendant. And it's clear as day to me that, like, once again, there's no way that 15 cars would fit in there. And by him changing that lane, I can just tell that his front bumper was too close to the rear bumper. It just, he made his left turn was so slow that eventually it's almost like if the truck tractor is getting away from him.
Okay. Your Honor, I pass the witness.
Trooper, you had mentioned that Mr. Arriola, in your estimation, had about 60 feet in between him and the tanker, correct?
Yes, sir.
And you had also mentioned that you had also mentioned that 60 feet would be roughly 6 car lengths, correct?
The average car is about 15.
Okay. So 4 to 6 car lengths?
4 car lengths.
Okay. And it's your testimony that Mr. Arriola, being 4 car lengths away from this tanker, would not be able to safely stop should he needed to do so.
He needed to be 15 feet. He was only at 4.
So what
He
I'm
need-
asking
he
you
needed to
though
be at
is,
15 cars.
okay, he needed to be at 15 cars and he was only at 4 cars, right?
I'm sorry, 10 cars. 10 cars.
Okay.
It was
So-
only roughly about 4.
So what I'm hearing is it's not possible for Mr. Ariola to safely stop without colliding with the tanker by only allowing 60 feet in between him and the tanker. Is that what you're saying?
Yes, sir. He was following too closely. When we factor in the perception reaction time, there's no way he would avoid a collision. That's correct, sir.
Now, you had also stated that the numbers that you use to factor whether or not he could avoid a collision, those numbers are not in the law whatsoever, correct?
No, sir. That would never be in the law.
Okay. I'll pass the witness.
Mr. Lamb?
No further questions on this portion, Your Honor.
Okay, do we need to break anyone before we move on to the search?
Yes, Your Honor. I'd ask that we take a little bit of a recess so that I can kind of, originally me and Mr. Pettis discussed that it was only going to be the traffic stop, so I have not had due time.
Mr. Lamb, Your Honor, what we could do, if you want, is have the court rule on this, and if it's denied, we could take up the other matters later, if you'd like to. If Mr. Lamb doesn't have object to that and the court doesn't, I'm okay with that. I didn't want to catch Mr. Lamb by surprise. I'm working with a digital file and a paper file, and I just saw my notes, and I figured I needed to include that.
Yes, Your Honor. I mean, we discussed before this hearing and this morning that we were going to be doing it on the traffic stop. I have not had due prep for case law and for anything else for the search issue. So the state would have no objection to if the court would rule on the traffic stop violation at this point, and then.
Okay, argument on the traffic stop?
Your Honor, may I proceed?
Yes.
Your Honor, in this situation, the case law stands that with Ford v. State and Macklemore v. State, the court can give the cites to the court later, that in both of these cases, there are specific articulable facts in which the officer has to present to the court in which why a traffic violation was presented or was done. A motion to suppress being granted in this situation is only applicable if the court finds that there were no specific articulable facts that was presented to the court to establish that there was reasonable suspicion for the traffic stop to have occurred. In this case specifically, the trooper is able to tell the court how fast the defendant was going, and in using the training and expertise that he's gained from multiple years at the academy, and using references such as the lines in the video and the speed limit in which, or the speed in which the defendant's traveling, he's able to determine with those facts, those specific facts, that the defendant in his operation of his motor vehicle gets too close to the tanker in front of him. And that's shown in the video, where at that point, when he's crossing the lanes, the distance between his vehicle and the tanker are within that range in which, if presented with an accident, if the tanker were to stop completely, if an accident were to happen and the 18-wheeler or the tanker in front of him were to just hit a deer, or as the officer stated, if there was something in the road in which the tanker then stopped without any due warning, Mr. Ariola's vehicle would be in that distance in which he would have crashed into the tanker. That is the point of what the statute in which Mr. Bettis had presented to the court, 545062, and the following distance. In that, it specifically states an operator shall, if following another vehicle, in this case, Mr. Ariola's vehicle and the tanker in front of him, must maintain an assured clear distance between the two vehicles so that the operator can safely stop without colliding with the preceding vehicle. Using the trooper's training and using all of the factors and the specific facts to this case, the trooper is able to identify that the defendant's vehicle and the tanker in front of him are too close in distance. And if something were to happen, his vehicle would collide with the tanker in front of him. It follows exactly with what the statute says and with what Mr. Bettis had referenced was 545.062. With all of these factors, with all of these specific facts to this case, the trooper executed an appropriate stop for traffic violation of following too closely, and it's an appropriate violation for the trooper.
All right, Mr. Perez.
Judge, with all due respect, I believe that the case is very clear. The officer states that Mr. Areola was following too closely, and we have video showing that he was not following too closely. Judge, there's also been testimony given by the trooper stating, or at least suggesting strongly, that the trooper had already intended to stop Mr. Areola. The trooper listed facts that I would contend ordinarily would not be in an offense report, but for the trooper trying to justify an impending traffic stop. The officer listed that Mr. Areola began to slow down where other motorists were passing him, that he was self-soothing by touching his hair, that he was staring into the bushy area, that he had varied his speed between 69 and 75, and that most oddly enough, that Mr. Areola was being overly cautious. So number one, Judge, I would argue that the trooper's statement that Mr. Areola was following too closely is a pretext stop. I believe that his actual motivation was the fact that he suspected Mr. Areola of illegal activity from the beginning. And he used the allegation of following too closely merely as an excuse to justify the traffic stop. And moreover, Judge, notwithstanding that pretext stops are allowed in Texas, the actual legal grounds justifying the stop has to be legitimate. And here I don't believe that it is. The trooper testified as to a very complicated formula that he stated was taught to them in their training and in their manuals, and they use this calculation to decide whether or not a motorist is following too closely. He spent a great deal of time elaborating that with the state. And then on cross-examination, he proceeds to tell me that he did not even do this computation before deciding to pull over Mr. Areola. So on one hand, we have this big, long discussion of how he knew Mr. Areola was following too closely because of this mathematical formula. And then we have the trooper squarely state that he did not do the formula. I believe the officer's exact words were, "I didn't do the formula. I did another formula." And I could have sworn he said, "I did an invalid formula." If anything, that raises a big red flag as to whether or not Mr. Areola was following too closely. And I think that big red flag, coupled with the video evidence, I think that any doubt would go in favor of Mr. Areola, the defendant. Judge, there's just not any evidence here that he was following too closely. We have a lot of a lot of self-serving statements. We have a lot of suspicion, but I don't think that we have any evidence of him following too closely. Judge, I'm going to ask that you find that the traffic stop was illegal, and as a result of the illegal traffic stop, I'm going to ask that you find the drugs seized from Mr. Arreola to be fruit of the poisonous tree, and find that those drugs are to be excluded from Mr. Arreola's upcoming jury trial. Thank you.
Your Honor, brief rebuttal.
Yes, sir.
I'm going to share the screen again, Your Honor. This is the reference in which the trooper has been discussing. The distance between his vehicle and this vehicle is the appropriate amount of distance. And from his view on that day, this distance to this distance, his, pardon me to the court reporter, the vehicle in which Mr. Arreola was driving and the tanker in front of him were not the appropriate distance. And from his perception and from his view, this distance between Mr. Arreola's vehicle and the tanker in front of him would have been in violation of 545.062. Mr. Bettis is discussing how he didn't do the computation or specifically do the computation, but these come in with those factors of which he's gone through the training. He knows what these formulas mean and how they interface with each other, and that he's gone through multiple criteria where 70 miles per hour, this is how far somebody needs to be that's at 70 miles per hour. And that's the formula that they've gone through, they've trained on, and he knows that formula. And that's the formula in which he's used to reference in this case as to how far Mr. Arreola's vehicle had to be from the tanker in front of him. Now, the trooper did discuss in his report about how there was certain factors in which made him pull out of the median to begin following Mr. Arreola. Those are perfectly appropriate measures in which the trooper can start following somebody if they have suspicions. However, in this specific case, Mr. Arreola conducted a traffic violation, and that's what he was being pulled over for. And that's what the trooper has specifically stated he was being pulled over for, was that traffic violation. And so, Your Honor, the state would request that you deny or ask that you deny the defendant's motion in this case based on the traffic violation.
May I say one more thing, Judge?
Yes, sir.
Very sorry. Judge, if we're to believe what the trooper has testified to, it's going to lead to an absurd proposition, respectfully. The trooper testified that the average car is roughly 10 feet long. Then when I started getting into it later on, towards the end of the hearing, he had said, no, well, you know, my car is 15 feet long. So, but even using even using both figures, Judge, if we're to believe the trooper's statement that Mr. Arreola was following too closely, this court is going to have to find that 4 to 6 car lengths behind the tanker was not enough on a clear day with very little traffic, without any road conditions, weathering conditions, and with a driver, in the trooper's own words, being overly cautious. If the court is to find the trooper was correct in believing that Mr. Arreola was following too closely, I believe those are the conclusions that the court is going to have to find, that 4 to 6 car lengths under perfect, ideal conditions with an overly cautious driver going under the speed limit is not enough. Using the officer's formula, the court would also have to find if that officer's formula is to be the standard by which this statute is measured, Mr. Areola, by the trooper's own testimony, would have had to been 15 car lengths behind the trooper. And I believe that is an absurd proposition, given the characteristics of the road conditions, the weather conditions, the traffic, and frankly, the impeccable driving by Mr. Areola. Thank you, Judge.
All right, I've listened to the evidence carefully. I will deny the motion to suppress on the stop. Do you want to select a date? Do you want to do this Wednesday? When do you want to come back?
Your Honor, let me speak with my trooper and make sure that he doesn't have, I know that they've been doing training and everything overall. So if I can have a breakout room with my trooper, I can kind of get a date and then see if there's any other dates that you are available that we can proceed with the hearing in front of you again.
If I could propose an alternative, Your Honor, if you don't mind. Given the amount of the drugs here, I don't see any way how this case is not going to go to trial. And I do think at that point, we're going to be asking for a jury instruction for the jury to consider the traffic stop. I do have additional issues that I am going to have to bring up in order to render effective assistance of counsel, specifically the vehicle search. And I haven't told Mr. Lamb about this too, but I think at trial, I might have to contest Mr. Areola's confession as well. Now, in complete candor with the court, I don't think that it would be appropriate to take up the court's time during a pretrial hearing for those matters, because frankly, they're going to be uphill climbs. This was our best bullet in the gun, and I do want to respect the court's time and judicial economy. I'd be fine with taking up those issues later, and preferably, if the court doesn't object and Mr. Lamb doesn't object, if we could have that as part of his trial, that would be much smoother. I think those would be very quick issues.
I'm willing to make time now, or make time in the future, or make time at trial. It's whatever the defense wants.
Okay. Can me and Mr. Lamb have a few days to talk about it and see if we could come to an agreement? We work pretty good together, and I'm just trying to make it simplest for all parties, including Mr. Areola.
Yes, Your Honor. I mean, that'd be fine with me. I would be okay if we just reset this to the 60-day reset date for, I believe, would be May 4th.
Okay.
And then if anything does come up and myself and Mr. Perez talk it over, we may just be able to either, if we need to set it for something, we can get it set. If not, we can set it for trial.
Okay. Thank you. And
that was 6/4?
May 4th, Your Honor, I believe.
May
Is
4th, 5/4.
Your Honor, may the trooper be excused?
Yes.
Thank you very much, Mr. Trooper. Have a good one.
Yes, sir. You too. Thank you.
All right, and before we go over the docket, let me ask Mr. Rivas from Public Defender's Office, where do we stand on getting the folks who are in custody interviewed?
Sir, I've reached out to Officer Cantu over at the Atascosa County Jail. I'm still waiting for her reply.
Judge, I'm sorry. Me and Mr. Areola excused?
Yes, sir.
Mr. Areola, I'll be in touch. We have recourse. We'll talk about it later. Don't say anything right now, okay? Okay.
And Judge, I specifically noted to Officer Cantu that you were requesting updates on these particular individuals that you requested. So I added that into the email. I haven't heard back from her yet.
I'm currently in the room with Ariola. I haven't been on my email. Sorry about that.
So does that mean that they have not been interviewed yet?
That is correct, sir. If we're talking about Bedwell, Gaitan, Cantu, and Hernandez.
All right, so let's set all of those for 3-3. So that I can get someone appointed by then. And are we ready to start going over the dockets?
Yes, Your Honor. State's ready.
All right, this crashed a while ago. Let me pull up the criminal additions. All right. So Sandy Ayala, what do we have?
323 to plead.
Vasquez,
Your Honor, to be frank with the court, I may have been in the breakout room whenever some of these were going through. So if Miss Riley or
I've got lots of
March 8th on that one.
I've got lots of notes, but I haven't looked at them.
okay, so yeah, if Miss Tristan or Miss Riley want to announce, I'm not opposed. March 8th, I think was what.
Yes, March 8th on that one, sorry.
All right, and this just switch to Greek characters right in the middle of my typing that. I'm going to put needs attorney. Benavidez 4-5 sentencing.
4-5 sentencing. On Your Honor, on Bedwell, what was the date or attorney?
3-3. We don't have an attorney yet because they have not been interviewed.
Okay, I just wanted to make sure. I know that Mr. Finkel had announced, but I wasn't sure.
Yeah, his announcement was that was all. Tehran.
3-8.
Okay. Rice.
5-4. Sorry, okay.
Oh, no worries.
Which county is it?
Gaitan.
I show nice eye, Your Honor, unless.
I have 4-1 on Gaitan. I show
He's in custody.
Okay.
I'm going to put 3-3 and 4-1 because he still has he's been appointed perhaps, but his financial voucher has not been approved. So he's still stuck in limbo. They're in the determination queue, running up our bad statistics on appointment. So 3-3 and 4-1.
3-3. And Dan, can you add that to your list?
Estrada.
323.
Carrillo. Final judgment. Although I haven't signed that yet. Booth.
317.
Ariola 5-4.
Yes, sir.
Caffey, final judgment.
Yes, sir. Oh, and Judge, I do have a updated judgment that I will forward to the court right now with 256 days on Mr. Caffey.
Okay, thank you.
All right. He said he was needed a year or?
No, he had 90 days plus I think he had been in custody since what he said was August and then had transferred over to TDC at some point. So we were missing the TDC days from August till now. So he has about 256 days. I will also forward this to, and this is in reference to also the days that Mr. Adams had sent me. I'd forward those over to our girls, so they would take a look at those. What I'll do is on the judgment, Your Honor, I will also submit and forward it over to Mr. Adams by email. And if he has any objection, he can say
Okay,
it.
I went ahead and made that change. You don't need to send.
Oh,
anything.
256. Okay.
And if again, I've already said if he has heartburn, he can file a motion for new trial, but that hopefully that does it. If not, then I mean, we'll get it right later.
Yes, Your Honor.
So let me post that to Ms. Benavides. All right, this is different. Atascosa County has both a, yellow light showing that it's broadcasting and it's muted at the same time, okay? All right. Hall, Nisai?
Hall, nice eye, Your Honor, yes.
Staggs PR bond to be drafted. Do we have dates also?
May the 4th.
Medrano,
3/8.
Wisdom,
3/8.
Cortez,
323.
okay, and then on add-ons, Annapolis and Cantu, 3-3 because they still need attorneys.
Yes, sir.
Correct.
All right, and give me just a moment to check one thing out and then. Okay, I know some people wound up on confusion about whether they were supposed to be on the docket Monday or Wednesday, but Hall does not appear on the Wednesday docket, so. Okay, on the add-ons, I also have State versus Joylyn Martinez. Who got appointed to her?
Ed Adams.
Eddie Adams.
You want the cause number, Judge?
No, I've got it, 21-264.
Yes, sir.
And is he still on for Wednesday, or did he file something?
I don't know about that, Judge. I'm not 100%
And
sure.
then 61, 21-261 and 62, Roseanne Perez, still on for Wednesday. She has Adrian Perez.
Yes, sir.
And then 21-260, Austin Renner has the Public Defender's Office.
And what was that name, sir?
Austin Renner, R-E-N-N-E-R.
Renner. And you said TRLL, the Public Defender's Office?
Yes.
Currently set for some, so date he's.
2102-0060, you said.
What was the date on Renner?
Yes, ma'am.
Well, if we haven't heard anything, I assume 3-3.
Look real quick and I can let you know real quick.
That's when it was set, or should have been.
I just don't recall that name yet.
Yes, it is on the 3rd.
Somebody give it to you. Yes, go ahead and go to lunch.
All right, so anything else we need to work on?
Nothing.
Judge, did you read my chat?
No, I haven't read any chat. What
If you
did it
can-
say?
I looked into the ones that were on for today that were not on the docket.
Yes, you said that you got two sets of notices with different dates or something?
Yes. But
Okay,
the people
right.
who were, well, I was looking at the docket for Wednesday. Those people had today's date on the letters.
Okay. All right, and that's fine. I mean, that happens, so they've gotten attorneys, hopefully, I think all of them.
All right, thank you.
All right, so let me ask the jail and Mr. Rivas I'm gonna ask Lori to lead this running and ask them to speak and go in a breakout room where they can just do it once I leave and see what we can do. I understand that there's only one breakout room at the jail and that it gets crowded on criminal days. See what they can do about coming in before 9 or going in the day before or the business day before or something, what we can do so that we're not delaying court to do all the in custody interviews over the Zoom room.
And Judge, I think we are going in on non-court days and trying to get those done when possible. We're running up with the general problem that there is only one Zoom. For investigators, everything like that.
Okay, yeah, and I understand, but that's why I'm
Right.
saying when we can pull the dockets and look and we can determine who is in that category, see if we can't, even if it's coming in at 8 a.m., you could at least get 2 or 3 of them done possibly before the dockets are called. It's usually well after 9, if not 9:30. It was probably 10 before we needed a defendant this morning. That would have been a couple hours if we'd started at 8. But again, it's going to take a while to get this worked out. And
On
hopefully,
my behalf, Judge, I'll do whatever I need to do.
okay. And y'all are still supposed to be working from the house and not, or from office and not going out places?
Except without express permission on individual matters. So, yes.
Okay. All right. Okay. Anything else y'all need me on?
No, Your Honor. I know that this is kind of going backwards way, but my other computer's microphone isn't working. So I was going to ask Lori if the Frio criminal docket was still going.
Let me check with Jennifer. She was talking. So let me double check and I'll let you know real quick.
Thank you very much, Lori.
You're welcome.
Okay, well, I'm going to go ahead and take off. And
Your Honor.
Here. Oh, I'm
Yes,
sorry?
I wanted to ask you if I was able to send you an order amending the terms of probation. The defendants to turn himself in today. Do you want me to email you?
No, just go ahead. If you have it ready, just post it in chat.
Okay, thank you.
Are you still having your criminal docket going, Jennifer?
No, I just called city landlord on.
Okay.
Okay, perfect. Thank you. I got it.
Oh, sorry. I didn't know I was not
No.
muted. I'm sorry. I'm
Thank
getting
you.
in trouble with that mute. Sorry. They're done. Okay.
Thank you. Judge, do you need anything else from me?
No.
Have a good day, Judge.
I need to stay on though, right, Judge, for that order amending?
Yes, if you'll hold on until I get it.
Okay.
And Judge, you want me to put Dan Rivas in a breakout room with the Atascosa County Jail? Is that what you asked a moment ago?
Please.
Does Mr. Boyer need to go in there as well?
If he wants, that's great.
Not for the affidavits. I don't need being there.
Okay.
If anyone needs me, just let me know. I'll come back.
I think we might be done, aren't we, Judge?
I
If
think
that's-
so.
Okay, Mr. Rivas and Atascosa County Jail, are y'all there so I can put y'all in a room
Yes, ma'am.
together? Okay.
Yes.
All right, let me get you into a room. Put y'all in breakout room 2.
All right, see you tomorrow, Joe.
I'm gonna step away for just a moment, Judge.
Okay.
All right, I just signed and posted the Keeler amendment of probation order to Ms. Benavides. Ms. Lara?
I'm gonna see right quick if it came out okay, Judge.
Sure.
Got it, Judge.
All right.
Thank you, Judge.
Here. Certainly. You'll have a good day.
You too.